My lords, may I seek your lordship's indulgence? Your lordships have kept the Sahara matters for 5th, which in any case now is a holiday, and on 8th of January had permitted 2 other bidders with 1,000 crores advance to also participate. We have already sent an urgency letter to the registrar. We are also interested with the same amount being deposited in better terms for the Versova land. All that we are praying is, my lords, before the matter is taken up, if our application can be taken up, because SEBI was directed in the amicus to give reports in any prospective
Just
bidders.
move a letter.
I have already moved it to the registrar on 23rd of January, my lords.
They'll place it before.
My lords, our only concern was before the next date. If our
It will not be before the next date, it will be on the next
My lords, I'll leave it to your lordships. The only thing I'm pointing out is your lordships in the other two matters.
We cannot have a matter, the date fixed. We'll take it up on that day. We cannot.
No, my lords, I have no difficulty. I'm only pointing out one thing and I'll leave it at that. On 8th of January, your head lordships had directed SEBI to give reports on the other two bidders. So all that I'm saying is if my application comes up on the same day, the SEBI report won't be there.
Please circulate your report that we can't have a special.
My lords, can I circulate it to the amicus and to SEBI?
Correct.
In advance? I'll do that, my lords. Once your lordships have said, I'll do it.
cannot have a special sitting.
No, very well, my lords. But with your lordship's permission, I'll submit the report and mention that. I had mentioned it. Very grateful. Very grateful.
With my lord's permission, shall I mention a very serious and urgent matter?
Please move a letter of.
Only 1 minute I will take, my lords. 1,700 students have been thrown out of the premises in the mid-term and mid-year. The examinations are going.
Please move a urgency letter. It will be taken up.
Please.
The matter has been settled between the parties.
Respondent is not served.
The matter has been settled. I have instructions to press protocol. Yes, please.
It's settled. The matter has been settled, and the petitioner wants to withdraw the present transfer petition.
Wait.
The statement made. Transfer petition is dismissed as withdrawn.
Item 2, I appear for the state. I filed my counter. I'm carrying my.
You are not filed it on. It's not on.
Yes, not on
This was.
In the counter, they are saying that out of 36, 6 witnesses have been examined and 30 are left to be examined. And that I am in a jail since near about 2 years, my lord. I would be completely.
Chivin aside.
1 year, 11 months.
And what is the stage of trial?
6 witnesses
Six
have been
witnesses have
examined.
been
Have the public witnesses been examined or?
That according to my instructions, that
Your lordships has page 4 of my counter. I've mentioned the number of witnesses.
Does evidence has been recorded? Rupa.
Rupa's.
Rupa's evidence has been recorded or not recorded?
I'll have to confirm that, your lordship.
I will confirm, my lord. Just pass it
No.
on. I will confirm.
If your lordship
Let
pass
me
it
put it this way. 161 of Rupa says 2 things which are contradictory. One, that she's herself involved in the trade, and then she forced her into trade and she was taking money from her and others as if she's a head. There are 2 things which are contradictory.
I understand.
Because even in the house, with regard to the house, there's somebody else who's the owner of the house.
Already been granted.
Kohli is the owner of the house. Now, if the owner of the house is involved, why will he give it on rent to anybody? Are you prosecuting Kohli also?
Yes, my lord. It's accused number
Then if Kohli is being
she has been granted bail.
owner of the house, how will you then justify that she's a tenant and she was asking others to come in? There won't be any agreement or anything like that.
Srirang, there's no decoy or anything. You have just gone there and seen the 3 ladies. Normally,
This petitioner was not present at that spot. Later on, it was discovered that she is the main person who is handling everything there.
Yes.
They had some secret information. They went there, and I understand your lordship. If lordships can defer this, I can place the deposition of Rupa if required.
Let it be, let it be. Like, normally you examine the public witnesses at the first call. Right, and let me put it, there will be something which will be added. Because Kohli is the main person.
Yes, sir.
And here was a hotel. Let's also not forget, the hotel people know exactly what is happening. Room which was taken. The person who is there will know everything. Now, in order to show that there is somebody else and not the owner of that, the building itself, you put the blame on the other. Let it be. Of the building where they were found is also being
This
prosecuted?
is accused number 2.
No. Yeah, Kohli.
Yes, yes.
Owner is Kohli.
She is the accused number 2. She has already been granted.
He's been granted bail only on the ground that she's merely the owner.
There are two places. One is Kohli's residence.
Yes.
The other is the place where the raid took place. Where the raid took place, the owner of that building is also being prosecuted.
Yes. That's Kohli.
That's Kohli only.
1 lakh, 1 year level.
This is the only place, Manoj.
Let her come out only. The appellate so has already undergone incarceration for 1 year and 11 months. Stop. On going through, it is alleged on the part of the appellant that she is herself a victim. A fact noticed by us while issuing notice. Stop. Next bit. Having regard to the facts and circumstances of the case, we accept the present appeal and direct that the appellant so and so shall be released on bail during pendency of trial in the charge sheet arising out of FIR number so and so under section so and so on terms and conditions to be fixed by the trial court. Explainer. The interim judgment is set aside, then the appeal is allowed for post-set terms. The clarified grant of bail will not be treated as expression of opinion on the basis of the bail.
Grateful.
Yes, please. Well, in this case, the petitioner is in custody for more than 3 years, 7 months. So the case at the stage of framing of charge for the last 3.5 years. Earlier also I moved that application before your lordship and gave a liberty. The case is at the stage of framing.
Owner of the truck.
No, my lord. The owner of the truck is A4.
A4.
Yes.
Not the,
Yes.
you're not the owner.
Yes.
But was he in the truck and he got down a few places before?
Absolutely, my lord. This has came into light.
And did the CDR show that on that day he was in that area?
Yes, my lord. That is the only issue, my lord.
And your Aadhaar card is in the truck. Why would you leave your Aadhaar card in the truck?
That is the plan.
You need to show your Aadhaar card to sell ganja.
No, Your Lordship, because he got down from, this is the statement made by the co-accused, A1, A2, based on which he has been
Be
implicated.
the count.
Notice returnable in the week commencing 24th of March 2025. Notice will be issued by all modes, including Rustage.
I would like.
Which by, I'm appearing on behalf of the applicant. By way of this appeal, Milos, they have
Had earlier made a statement that you'll be issuing notice to everybody and you are now giving it to them. Mr. Roti had made that
This
statement.
is not a home buyer case. This is a minority shareholder. It's a public listed company. It's a minority shareholder. And in respect of a minority shareholder, your lordships have already decided in JP Kensington that their entitlement is as per
Just 1 minute. Just 1 minute.
Please, Milos.
You never went on a 60 subsection 5 anyway. First time you're coming here.
That's
yes,
right.
Milos, but the issue is, Milos, my humble submission is, the issue is that, Milos, in the entire CIRP, if any of the stakeholder is getting zero treatment in terms of the reduction to nil, that issue is pending for the Honorable Supreme Court.
No, that's not correct. That's in those, please. That's in those cases where the books of account of the corporate data itself indicate a particular amount is payable or is debt due. Then in those circumstances, sometimes what is happening is the amounts are being reduced to zero on account of the fact that you did not make your claim.
Please, Milos.
In those cases, we have issued notice.
One coming yesterday.
This is
The
a
other
case
bank-
where SEBI regulations require that in the event the company is being delisted or involves a listed company, you have to set aside a corpus of 1 crore for exit of the non-promoter shareholders.
Milos,
That has been upheld by your lordships in JP Kensington judgment, which
I-
your lordships were co-authored.
I am referring to a judgment.
Maheshwari was authored. And Milos,
I'm
in
sorry.
this case, that 1 crore has been kept in deference to what has fallen from your lordships in JP Kensington. And this person has not challenged, some others challenged, and the NCLT has dismissed those. If I have, Milos, I have prepared a compilation of all the this petition.
So I just went by the order sheet which is placed with the office note, which says issue notice. So I assumed that this was a case which was
Which is
connected to
not.
that.
Yes, Milos, that component is challenged, Milos. I am also
This is
challenging
a
the.
case as Rashmi, but now
Yes.
this be a case of the flat buyer or somebody else?
No, Milos, she is also she is a
These are
flat buyer.
buyer's case.
She's a flat buyer. But Milos, I am on a different parlance. Milos, what I am saying that this honorable court, Milos, has issued notice so far as the
No, you will
treatment
not,
of
as a minority shareholder, you will not get anything. Minority, no, you will not get anything.
Milos, I am saying something else. Only
Are you a minority claiming on the basis you are a minority shareholder?
Milos, I am a minority shareholder. Lakhs of minority shareholders. The question of law which has arisen.
No, sorry, please. Minority
only-
shareholders come down. They are the rock bottom.
Order. Milos,
What
this
is the
honorable
rock
court.
bottom, please?
Milos, this honorable court.
No, please. Nothing doing.
Milos, hear me out for 2 minutes. 2 minutes, Milos. The question of law which is involved.
But there is no question of law in this. Minority shareholders will be at last.
Milos, we are
Because
the-
shareholders' rights are at the bottom after. If the,
It's a listed company, Milos. It's a listed company. There are lakhs of shareholders.
you come to the last. You come in the last.
That treatment in the 53, I am submitting that only, Milos. That we will all get the treatment within 53. So the person.
As long as fully. Today, the issue is the creditors are not being paid fully.
Yes, Milos.
Everybody is not being paid fully.
Yes.
So you will not get anything.
So therefore, Milos, it is other way around. This is what I'm trying to say. That Milos 53 mechanism that one can get zero in the CIRP, that is considered by the Honorable Supreme Court.
Sorry, there cannot be any doubt about it.
Milos 53 mechanism that.
Sorry, there cannot be doubt about it. That somebody will get zero there cannot be doubted.
Look, it's not about zero. It's about the value below the liquidation value.
No, please, it cannot be.
So
that value below the liquidation value will only arise if after paying the top rungs, something, some proper.
Therefore, my lords, in the case of an operational, may I put it in this way, my lords?
The lenders have taken 30%.
You're not even an operational creditor, you're a shareholder.
So my situation is more grave with all respect.
No, your situation is much worse.
My lords, my situation is more grave because it's a public list, it's a listed company.
Sorry, please.
Lakhs of
Shareholders take the risk.
Lords,
Shareholders take the risk. The creditors do not take the risk.
Lords, we are not a part of the COC. We don't have
cannot
the
be.
say in the COC.
Sorry, please.
Only
Sorry.
one judge, one order, my lords, which my lords have.
No, not required, please. Not required.
All right.
We are not inclined to interfere with the impugned judgment, and hence the appeal is dismissed. This
Please, this is the matter your lordships possibly indicated.
Look, let me put it, if we're going to accept all these pleas, we're going to have an absolute CRP will completely
We have to go into it, my lord. I'm not saying one way or the other.
If we accept this, in fact, the central government should come up and say, sorry, we are not accepting this stuff.
No, kindly allow me, my lord. That there is a separate question of law, my lord, which arises. And the question of
We are referring, okay, we are straight off referring Rainbow to a larger bench.
Security is admitted.
it's a two-judge. The lordships can examine.
Referring it so that this problem gets sorted out once and for all.
Only a minute. Only a minute. Allow me to. At least allow me, my lord, to say what I want to say, my lord.
Mr. Tushar Mehta, it cannot be. All your VAT taxations have the same legislation, same.
I'm slightly on a different point. Your lordships are on these facts. I'm slightly on a wider point, which I think your lordships may consider. But the creditor, under the definition clause under 310, is defined, my lord, having three categories. Lord, one is financial creditor, another is secured creditor, and third is operational creditor. Correct, my lord? Kindly pause here. Then 330 defines security interest. Your lordships may have to decide, and there is no judgment on this point. What happens if a person is an operational creditor?
What happens to government dues? No, government dues will subsume all of them.
Can I complete?
Yes.
But can I complete?
Tushar Mehta, this will lead to a.
My lord,
this
can
will
I have the
actually make-
satisfaction of, my lord, reaching to your lordships, my lord?
We understand what you are saying. I'm going to refer Rainbow to 5 judges bench.
My lord, let me-
And that will be reconsidered and decided once and for all.
Lord, it is already.
Who succeeds or fails, your provision is definitely.
I have something to say on that. I have something to say on that. Gujarat, Maharashtra, Madhya Pradesh, that I have to, but I'll have to, the foundation will be whether Rainbow is right. Otherwise, my lord, on facts, I have a.
No, I'm aware of it. I'm making the issue much broader.
Because I'm my lord, saying something slightly different, which I could not, my lord, convey. Lord, out of three categories, there is no judgment of this court with regard to what happens to a secured operational creditor. Operational creditor is last category. Financial creditor is the first category. But there is a third category contemplated where person is an operational creditor but secured operational creditor.
We will not accept it because what is happening.
Your lordship may not reject it. Your lordship will not accept it.
1 minute. All these operational secured creditors are relying upon statutory provisions.
So, no, there are other charges also, my lord, intra-party charges.
Why intra-party charges will be restricted to only the goods in question. Then the title in the goods in question, the issue will arise whether the relationship is that of a bailor-bailee.
No, what I am respectfully submitting is.
And there the title of the goods does not pass
No,
on or
what I am
has passed on, it will be the issue. I've yet to see a case of an operational creditor who claims security interest in case of non-supplies made by him. I'm yet to see one.
No,
It will be always, banks also bailor-bailee relationship.
Possibly,
The final charge is given by the companies also bailor-bailee relationship, maybe pledge, not beyond that.
May I say something? Lord, I'll my lord, by 2 o'clock, I'll find out. Possibly, I now realize there is one matter which is referred to a 3-judge bench, my lord. Possibly on this, my lord. I'll just, my lord, find out. Otherwise, my lord, it can go to 3-judge. That's all I'm.
No, you are referring to the securitization amendment of 2016.
No, my lord, under the IBC. Under the IBC, the court says that this may have ramifications.
No,
I was sitting, my lord. I got up and said that yes, I am also, I'm not aware, my lord, it's rainbow or something else. But my lord,
Rainbow was adversely commented upon by another bench. Curative is admitted. The
review was dismissed.
Review was dismissed, but curative is admitted. Curative may have more limited scope compared to reference to a larger bench by us, because then directly we are going to the merits of the judgment.
That is my lord's prerogative. As a my lord,
As a 5 judges bench or 3 judges bench, we directly go into the merits. In curative, our scope is limited by Ura's case. Otherwise, we go into when we do reference.
3 or 5, I cannot argue before my lord the chief.
And let me put we had enough legislations in VAT and other matters, because that was the main thing where the state government, all of them created crowned it. And they crowned it prerogative. And that was priority given to them and treating them as secure credits. All of them, all legislation, just take it across the board. And the Parliament was conscious. Parliament was fully conscious. Parliament was fully conscious when they drafted this legislation that they have to deal with this. The question is this: whether we give priority to taxes or we give priority to financial institutions.
I'm not on taxes at all.
That's it.
Taxes is one facet of a security interest created, my lord, for an operational creditor to become a secure creditor.
And the other option is, if you look at most of the clauses, it says notwithstanding any other law in operation for the time being. More securitization, the IBC's passed that. I think Securitization Act also they made an amendment to deal with the situation.
Yes, 2006.
Yes. That's what my lord just.
And Rainbow, you remember we were in the review.
Yes.
Banks, your own banks are on one side, government is on the other. But keep aside Rainbow, Madhya Pradesh provision it links it to subject to 530 of the.
Not 530 is for liquidation. 53 is another thing.
No, I know, but then when it is subjected to that,
it's not a complete.
529A comes in, 530 takes you back to 529.
Correct, my lord. That will have to be argued. My lord, I may eventually lose. But this is a
question.
That's
not what is being pointed out. The provision is not similar to the Gujarat provision.
That, my lord, can we not conclude right now? I have something to say.
Because that Gujarat provision did not make reference to 529 and 530.
But Maharashtra provision made it subject to the Central Act, which is IBC, which is relied upon. So I have to say something. I may succeed or lose. This is not an issue.
This is going to make it entirely unworkable. Your rate of interest in the VAT Acts is so high that, and you give them preference when others are taking deep cuts.
But ultimately, your lordships,
and what
obviously.
Is that? Obviously, the intent behind saying government dues was every nature of government dues. Whether it's
I'll assist your lordship.
Because you were not, neither you were treated as secure creditors, neither you were treated as operational creditors, neither as financial creditors. You are treated as government dues.
My lord,
and
I have
will subsume everything. Now, what is going to happen? Suppose the legislation has not made them secure creditors.
They are legislatively.
Let's assume some state legislature.
Under the IBC, they are.
1 minute. Suppose some state legislation in the VAT dues does not treat themselves as secure creditors. Correct? Now, those dues will become lower, will go down, lower down the order. Whereas one state government has made them as secure dues, they come up higher in the order. Is that fair?
That your lordships will examine. But
no, that's quite accurate what you are arguing. That mainly because the legislature has passed that and the central government was fully conscious, Parliament was fully conscious of this problem.
Amended. All stakeholders bound by the plan.
I think
take a cue from the Chief Justice's comments and address it legislatively. Because every state comes, no bank will sanction plans, because you see they'll take the big kitty with all penal interest completely gone. Who will
your
come?
lordships can rest assured. I'll not be arguing as if I am arguing for this particular tax department. I'll assist your lordships, my lord. I know this act preceded one detailed report of Injeti Srinivas committee. My lord, sir.
2019 Injeti, 15 Vishwanathan committee. 19 said all stakeholders will be bound in 13 and 2.
Examine those statutory authorities. I'll place them before your lordships. Lord, these are not the matters where we argue for success or loss. Lord, we argue to assist the court for laying down the law. I'll do that accordingly.
The objective behind this, when we refer to the government dues, it includes every
On
nature
the
and
last
kind of-
occasion, I said that it may.
And it will include penalty. In many cases, even includes penalty. And that also is then given a first charge, deemed first charge.
No, last occasion also, my lord, the day before, few days, my lord, I informed your lordships that perhaps, my lord, some interpretation might defeat the very intent and object of the act, my lord. We'll assist your lordships on both sides.
And in this case, let it be. Let it be because of that 529A, 530 difference.
Your lordships are not referring.
Judges or three?
By honorable two judges, my lord.
Okay, then we can deal with it in three judges itself. Then we can deal with it.
Before my lord, the Chief Justice, 3 or 5, I can't argue. Your lordships can have, my lord, 8,
No, then
7.
we can deal with it in three judges itself.
No, not in this matter, my lord. Then I will have to argue. That's all. Not in this matter, my lord. No, may I say, my lord, if your lordships are considering deciding in this combination, my lord, in this matter, my lord, then, my lord, your lordships allow me to assist. That's all.
My lords, may I just,
I, my lord, submit my submissions with.
Right on.
may I just make,
A larger question which arises for consideration is whether the dues are payable under the value added tax and expense of the state would fall in the category of government dues.
One more question, my lord, if your lordship permits. This is the question. I have a short note which I'll elaborate, my lord. But this would directly arise, my lord. This would directly arise. And he mentioned that, my lord, it may go against me or my favor, but that's not the issue right now. Last, second bottom, page 2 bottom.
No, you are not an operational creditor. You're not an operational.
I am an operational creditor.
No, you're not an operational.
This would be the question.
What is the service rendered by you? What is the service or goods supplied by you?
Kindly see the definition.
No. You read the definition.
Kindly, my lord, see the definition. Your lordship's name, my lord.
Operation.
520. But operational debt is 521 means a claim in respect of the provision of goods or services, including
21.
employment.
Read it.
Only, my lord. Operational debt means a claim in respect of the provision of goods or services, including.
What are you reading?
521.
520.
Then, my lord, 520, I'll read subsequently. That's how, my lord, it has to be read according to me. Means a claim in respect of the provision of goods or services, including employment or a debt in respect of the payment of dues arising under any law for the time.
No. Read it from top. Read it from before. It talks about goods and services.
Goods and services, including employment.
The goods and services. So basically, it's goods and services, but it also.
Or it's disjunctive or a debt in respect of the payment of dues arising under any law for the time being in force and payable to central government, any state government, or any local authority. And now read, my lord, kindly read the operational creditor. Means a person to whom an operational debt is owed.
Now I read the security interest.
Lord, before that, kindly read the secured creditor, my lord.
Yes, secured creditor.
210. Lord, would your lordship not consider framing the question?
I will do that. We'll do that. You may be right as far as 2821 is concerned.
No, I'm sorry, 310, my lord. 310, not my lord, 210, 310. Credit, your lordship have 310. Creditor means any person to whom a debt is owed and includes, now see, three categories: a financial creditor, an operational creditor, a secured creditor, an unsecured creditor, and a decree holder. So I can be a combination of two, operational creditor and also secured creditor. Now please see, my lord, 330. Secured creditors definition. It doesn't distinguish between financial and operational. Secured creditor means a creditor in favor of whom security interest is created.
Now read security interest in 31.
Yes, means right, title or interest or a claim to property created in favor of or provided for a secured creditor by a transaction which secures payment or performance of an obligation and includes mortgage, charge. Not according to me, charge is statutory.
Read it.
Hypothecation, assignment, and encumbrance or any other agreement or arrangement securing payment or performance of any obligation of any person.
Now read it carefully once again. It excludes operation of a charge created by a statute.
That can be, my lord, of you. But this, I'm just saying.
Consider one more thing. Even if you are a secured creditor, you are not a financial creditor.
But
so
kindly see 53. Financial creditor is not the first
hierarchy. Just read it once again because it's very carefully by a transaction. It doesn't refer to a creation by a law. Just read it carefully once again.
Yes, my lord. 331. My lord.
Yes.
Yes, it's not by creation of law. By
read it carefully.
Yes, but I just read. Security interest means right, title, or interest, or a claim to property created in favor of or provided for a secured creditor by a transaction which secures payment or performance. The transaction can be, my lord, dehouse the statute.
It goes beyond that. A transaction which secures payment or performance of an obligation.
Kindly add there. That's all I'm saying. It's a question of law, my lord. I may lose, my lord, but let the law.
May I just make one submission, my lords? My lords, in Paschim your lordship have adversely commented upon Rainbow, indicating that section 53 and 238 has not been looked into. Now, Rainbow, your lordship is for the curative notice has been issued by.
Curative scope is very limited.
Lordship, please.
Mughal's case is very limited. Whereas when we refer to a larger bench, then we are directly dealing with the ratio itself.
May I just indicate one more thing? Central government in January 23.
You argue when it is.
Solicitor is now not asking for the full component. He is now saying at least I should be treated as a secured creditor.
I understand,
and given whenever I fall in that.
In the waterfall mechanism, I appreciate, my lords.
It's not that, no, either full or nothing. Maybe
I understand, my lords.
Full.
Waterfall mechanism does not use financial creditor. It uses the word secured creditor. It's an arguable point. I may succeed or lose. That's not the relevant.
My lord, central government itself in January 23.
It's not correct. This part you will have to sort out where I stand in the waterfall.
And my lord, the central government in January 23 had issued a notice inviting comments, indicating that Rainbow probably is incorrect. I'm sorry.
Excluding general argument because government dues come below.
We'll consider for your lordship assistance one way or the other. Well, I'll put it both ways.
On the facts, your lordship may just consider. My lords, on the facts of this case, my lords. My lords, on the facts of this case, May 23, resolution plan is fully implemented. I have taken over the whole thing, my lords. So any change in this law with respect to that will have a severe repercussion on the resolution plans already implemented, my lords. I have taken over.
Banks who have got the money will have to repay.
It would always be.
You will not be affected because you start on a clean slate. They want the money to come from the banks. Financial institution. You are not going to be burdened with it.
As far as I am concerned, my lords.
How will you be burdened? You cannot be burdened.
That's exactly. Today, my lords.
Mr. Baruka, the bench is with you.
No, I understand.
He is only referred.
I understand, sir.
Some of the issues which arise to consideration are: one, what did I say?
Newspaper and value-added tax enactments of the states would fall under the category of government dues.
Government dues or operational secured creditors. With the operational secured creditors will be single inverted commas. Question will also arise whether the government dues are covered by the definition of security interest in section 3 within brackets 31 of the Insolvency and Bankruptcy Code 2016. Stop. We may note that the decision of this court in Rainbow, what's the full citation of Rainbow Papers? Rainbow Papers Limited.
Rainbow is 2023.
9 SCC 545.
Sale tax officer versus Rainbow Papers Limited,
23, volume 9, SCC 545.
has been subject matter of some decisions, including
Can I seek a lot? I'm on a caveator matter is reached. My colleague is.
including which is that
Paschimachal Vidyut, let's have this. Vidyut Vitran Nigam Limited.
Paschimachal.
Let's have a copy of this judgment.
Raman Ispat Limited.
Paschimachal Vidyut Vitran Nigam Limited versus Raman Ispat Private Limited and others, 2023-10, SCC 60. First off, in order to settle the controversy, issue notice returnable in the week commencing 3rd of March 2024. First off, we clarify that pendency of the present appeal would not be a ground to adjourn proceedings proceedings under the Insolvency and Bankruptcy Court and will not amount to stay of the scheme which is already sanctioned.
I apologize to state the obvious. Would my lord state that everything will be subject to what opinion?
That's obvious. You will get the money from the pocket of the banks. You want that? Please take instructions. Please take instructions from the Ministry of Commerce and Banking.
That's what
I appreciate.
as I see success.
Should they issue notice to them?
Lots of make sense to do that.
After all, somewhere, as far as he's concerned, he will not be burdened.
I appreciate it.
He will not be burdened. That's very clear. He cannot be burdened. And clean slate principle will clearly apply to it. You take it from the you want to take it from the financial institution, welcome.
So may I then request your lordship actually clarify that, my lords. As a successful applicant, my lords, this is a serious concern my client has today.
We are very clear on that.
Apportionment, no.
It's a question of apportionment.
Lordship. Highly good.
Your lordship, here's the disciplinary committee of our council entertained the complaint after 14 years of incident happened. It's covered by your lordship judgments, 2 judgments.
When we talk about when there is no limitation, we talk about reasonable time. Reasonable time depends upon facts.
Yes, your lordship.
Then it's reduced to 2 years. 2 years.
Your lordship, fact is that 1995 it happened, your lordship. In 2009 is your lordship. Can you hear me out about legal position? Even your lordship,
we have told you the legal position. Legal position is there is no specified period of limitation. Correct. One, but when there is no specified period of limitation, it has to be initiated within reasonable time. What is reasonable time depends upon facts of each case.
The fact is clear.
Facts of this case are glaring.
Your Lordship, fact is clear. 1995, the compromise happened. 2000, Your Lordship, kindly hear me out, Your Lordship, because 2 years suspension of his.
It is required.
I said,
No, otherwise you are even taken away the money. You have been off and back.
Your Lordship, there is a signature of the magistrate. So she accepted.
Illiterate lady.
I'm sorry, Your Lordship.
Illiterate lady. A compromise saying paying 60,000 rupees and the son will get a majority. He gives up all his rights with regard to inheritance, whether it be personal property or ancestral property. What do you say?
That's right and wrong.
It doesn't shock your conscience when you are.
Your Lordship, she can file an appeal against the order of the magistrate. It's
Okay,
not.
please. What sort of advocacy is this? What sort of rights we are trying to?
Your Lordship, but there must be some limitation in every law. There is a limitations. Yeah, after 14 years, even after 30 years, if she comes, even we will not be spared. Your Lordship, all the lawyers.
Nobody will do like this. Do you think lawyers are doing this?
Your Lordship,
I've never
she
seen a case of
accepted money, so she put signature.
Sorry,
Magistrate affirmed that.
Sorry, sorry.
Your Lordship, delays.
Delay condone. We do not find it good ground and reason to interfere with the impugned judgment and hence the appeal is dismissed. We list. Go before another bench. 8.
Even Your Lordship, it is one appeal is pending already.
Where?
That is before Your Lordship. 25595.
When is it listed? That will be also posted before another bench if my brother is sitting on that thing.
Your Lordship, both the matters.
Before a bench presided over by Justice Nasema in the week commencing 3rd of February 2025.
Please, Your Lordship. Application for extension of time, my lord, sir. We have managed to raise the funds by 2111. 6 days short, my lords.
You have been instructed, Your Lordship, for the simple reason that DRIT has dismissed the.
That's true.
And they have filed the appeal before Kerala High Court.
Not
on 6th.
That's
January.
No, it's only 6 days, Mr. There was only delay of 6 days.
Your Lordship, I'm not on that point. I'm saying that
Consequent.
this application was filed on 25th of November.
No, if you extend the time, then obviously he gets a benefit. But I'm a little doubtful whether we use the term or as.
My lords, Your Lordships, my lords,
I'm a little doubtful in my order.
Your Lordship, recollect, my lords.
It was determined as amount.
Right, my lords, page 14.
My lord.
One crore. It's a determined amount because
there is no or, my lord. This is the first para.
This is not your order, my lords.
As 25%.
Because this
you deposited the full.
My lords, 53 lakhs, my lords, I've arranged the DD.
No, depositing, I know that.
My lords,
Your-
I only
Your
argued
Lordship,
it
all
that
I'm
day.
trying-
Let the appeal be heard.
Your Lordship, I'm on different point. Your Lordship, passport order. The question is that this was filed on 25th of November. DRT dismissed their essay.
They have not deposit, no?
No, on 25th, they have challenged it in High Court. It's pending.
On what ground they dismissed it?
Look, please, we did cut that litigation also. That writ petition in the High Court will become infructuous. We'll simply extend the time. It will be better. High Court may extend, may not extend because it's our order.
Yes, Your Lordship.
So
That's
it
fine,
does
but the
it.
amount was
Let-
determined.
Let the appeal be heard.
Your Lordship, amount was determined. 2 crore.
No.
After the High
Look, there there could be a fault in our order. Instead of or, we should have used the word as. You could have come.
Yeah, but
we could have come and we could have come in.
My
Now
lords,
that
percent
High
is
Court has
1.97.
my lords, if I may submit, my lords, I'm for the auction purchaser, my lords. My lords had passed a specific unambiguous order on that particular day to pay the particular amount, because even in SLP they have not questioned with regard to predetermination.
Where we cautious of the fact. Therefore, I myself said or should have been as. Second paragraph is very clear.
My
It
lords,
should have been as instead of or. But let it be now. That's been. Look, let it be heard. Makes no difference. 5 minutes.
Lordship,
my lords,
only-
twice it was.
I would not have opposed the
my
Lordship.
lords.
This is a 2006 debt. 14 years. Two rounds of litigation.
Where he's paid the money, let it be out.
Your Lordship,
Right up.
but the amount is determined as 1.97. That's what I'm saying.
Right up. The application is.
To deposit the balance amount.
You're
25.
no,
No, he's only deposited 50.
In fact,
deposited 1 crore. Full 1 crore. Look, that's a mistake by us.
In fact, my
That's a
lords,
mistake
my
by
lords,
us.
in fact, that day, my lords, because I only, my lords, appeared before your lordships, my lords. In fact, with the whole contention was, my lords, 1 crore, because there was a bank guarantee also. Your lordships remembers, my lord, 3 crores. Then, my lords, there was a suggestion made. This was passed over, my lords. I recollect distinctly. And my lord, on the second occasion, I took instructions and came before your lordships, my lords. My lord suggested that your lordships may give me the leverage, either 1 crore or 25%. That was, my lords, probably, my lords.
Let it be heard on minutes.
My lords,
Lordship,
if I,
1 crore is determined, Your Lordship.
Doesn't make a difference, let him deposit that.
1 crore is fine.
Now, we are not going to, now that or whatever benefit he is taken, there's a judgment of the High Court now saying or means 53,000.
My only concern is that 25% will reduce.
Could have come back to us for asking.
It will bring down below 25%.
lords, if I may just
Which is-
one page of the High
That's all.
Order, my lords.
That's an application not required. Right up. IA number, MA numbers also. We extend the time for payment in terms of our order dated 4/10/2024 by how much, when did you make the deposit?
Well, it's, can make it straight away. I've filed the DD also before the DRT, my lords. So,
by period of 7 days from today, that is on or before 3rd of February 2025. In case the deposit is made, the appeal preferred by the applicant before the debt recovery tribunal will get revived and will be decided as per law.
In fact, Your Lordship, High Court had granted the extension earlier.
That's all.
My lords, the amount
Amount should be
specified, my
Lordship,
lords.
otherwise,
The amount is 53 only. We're not changing that.
1 crore.
53.
50?
3.
It will be below 25% then, Your Lordship.
No, why?
Yes, Your Lordship.
it would not
It
be.
is.
That's been quantified by the High Court.
No, Lordship.
You're
Sorry.
with 97 in 150.
It is 190.
Out of 6 lakhs plus 6 crores plus 97 was deposited earlier.
Yes.
Now 53 will be deposited. That will make it 150, which is 25% of 6 crores.
Exactly.
All I can say is below 25% now.
No, leave it.
It is below 25%.
That's all. Next slide.
My lord, on 3rd of Jan.
Incomplete. My lords, on 3rd of January, a similar connected matter was listed before your lordships. Your lordships had dismissed that SLP with liberty to the petitioner to raise expeditious. May I pass that order? Similar order may be passed in this. My lord, but there was a liberty was granted, but in this case, if because now the next date is 3rd of April, if the direction may be passed for expeditious.
There's no.
No Pawan's matter. We've got the order.
Same order. Yes, same order.
Lordship, similar appeal is pending before this Honorable Lordship, which is coming on 30th January.
They passed that order extending the time.
Kindly see the page.
But have you got the EC?
Yes.
You got the EC with you? Clearance, EC clearance?
In 2016. And also applied for reprise.
We made a wrong. The list and tag with civil appeal numbers 3799
799
-3800 of 2019 Union of India versus Rajiv Suri and other connected cases. Interim order passed in the said appeals will also apply.
Lordship, there is delay, Lordship, 64.
How much is the delay?
64 days.
Issue notice on the application contradiction.
Overlay.
Lordship, in this, one question I most respectfully and humbly, Lordship, also ask myself is hierarchy of courts and judicial discipline.
Honorable, in the week commencing 24th or 1st of April 2025, notice will be served by all modes, including Dusty. Next page. It is submitted that in the first round, the entire issue was resolved, settled as a specially petition or appeal was dismissed. Specially petition was dismissed by the court. By order dated 11/7/2022. The review was also dismissed. The respondent has taken possession of the other flat.
Taken the compensation also.
So the compensation.
The additional interest also, 2 lakhs.
He's taken it.
Compensation including additional interest. Next, it will stay of further proceeding before the National Consumer Disputes Redressal Commission pursuant to order dated, or we simply stay the operation of the order. In the meanwhile, there will be interim stay of the order dated 19 September 2024.
I am so grateful. Deeply obliged, Lordships.
Please, my lord. Lord, the present petition raises an important question of law, my lord. Whether an award passed by a unilaterally appointed arbitrator can be enforced, my lord.
What? 34, you don't raise that question.
My lord, at that point of time, my lord, in 2019, the law was not settled.
Law was settled.
My lord, may give me liberty with respect to raising issues before the execution court.
It will lead to huge havoc. It will lead to total turmoil in the.
You should have raised it at 34, saying that.
My lord, at that point of time, the law was settled.
Not rectified.
And in any case, the modification made by the court under 34 takes care of everything. They have withdrawn that part with regard to damages after lock-in period damages. The other portion is.
Well, as I agree with.
Pay up. Don't
but my lord, the lawyer's mistake cannot be.
No, it's not a lawyer's mistake. It's not a lawyer's mistake.
My lord, it is a unilateral.
This will not affect the decree. There is no merit. There is no merit in the.
My lord, may give me liberty to raise it before.
No, sorry, no more. End of it. There's going to be. There is no merit in the present special leave petition, and hence the same is discussed.
Obliged.
Please, ma'am. This is a petition.
Just one thing. Is there any clause in the agreement dealing with the substantive law, or which will be applicable, or the law of arbitration which should be applicable.
Well, that page 17 and the agreement starts at page 57, except P2.
Which page?
At 79 of it.
Yes.
The arbitration clause which is there. At any dispute or differences which wheresoever arising between parties are out of
the specific law.
No, otherwise not.
There is a specific stipulation with regard to the substantive law of which country will be applicable.
This only we say that the arbitration shall be in accordance with Arbitration Conciliation 1996. And
which clause?
The clause 27, page 79, clause 27, the third line of that.
Arbitration shall be in accordance with. Issue notice. Returnable in the week commencing 1st of April 2025. Notice will be served by all modes including us.
My lords, I accept notice on behalf of respondent number 2.
Notice is an advance notice to give it, accepts notice on behalf of the second respondent. Stop.
May I request that for a shorter date, because the main is the respondent number 2 who was abroad one. The number 1 is a party which is based in Gurgaon.
Doesn't make a difference. Let it come up in April.
Only a request for some shorter date.
No, it's fine. Let them come, let them file a reply. He will go before another bench. Let's call this to go before another bench. To be listed before the bench of the PV Margaret.
Or could it be on Friday then, my lord?
In the week on 31st of January 2020.
Very grateful. Extremely grateful.
It's an item 16. I seek a passover. Mr. Rodgi is on his.
Let him argue. Can you come? You can raise this plea anytime on whenever you want.
But that's not. I'll tell you, Lordship.
You can't. And let me put it. Look, when there is a consent appointment of an arbitrator, you forego that plea. And Section 7 of the Arbitration Act says, by consent also you can create an arbitration clause.
It is by consent, my lord.
And it's all the more murky because after evidence is being recorded, the plea is taken. That shows that you don't have confidence in the evidence being recorded.
No, that's not the point.
That's the point. Please make that point.
Mr. Chairman, your point that if the procedure part goes, the clause itself will not be there, would have been a good point to argue if you had not consented. That's the main point.
My main difficulty is because I'll tell your lordship, what has happened is on that clause, the Delhi High Court has been split. There are conflicting judgments.
No, we are not going. Therefore, we are not even going into that.
I may only answer the
consent part. You can't raise this. Look, this is the odd part.
Yes.
When a party raises, and that to a government in this case, raises the objection at the stage of evidence, shows you want to stall the evidence. You don't have confidence in yourself.
I'll tell you, lordship, what has happened so far.
And 16 says very clearly you have to raise it at the earliest opportunity.
But I know.
Why should we then interfere?
Well, let me just do a little bit of attempted justice on the consent point. Your lordship may be against me, not prima facie. Let me just try to convince your lordship what happened in this matter. Well, if your lordship there's a judgment of the Kerala, of the Supreme Court from Kerala, that if you are going to have an order, what has happened in this case?
Mr. Jetmalani, you can have a new arbitration clause created by consent also. When you don't deny arbitration clause, somebody relies upon it, you don't deny it, you create an arbitration.
Now, I don't want to go into the slightly controversial aspects of this. What has happened is, the consent was given orally. Please see the consent order.
That's fine. Fine, you should have raised that objection. You file an appeal over here after 400 days.
Moment, my lord. What has happened is, my lord.
Running away from the evidence, that's all.
I'm not running.
Quite clear. The officers don't have confidence in themselves.
My lord, I see all that. Please just listen. Just see the order of consent.
I see that.
Consent 1.
Fine, order of consent is given, but you accepted it. You would have otherwise moved an application for recall.
Nobody has given instructions. My lord, if the order is without...
You don't do it after 400 days. Estoppel equiescence is there. Sorry, Mr. Chittilan.
My lord, my rights under 34, of course, my lord, will remain.
We are not saying anything about 34. We are not going to keep quiet on that. We simply
but it can always
we are not saying anything about it. We will not say, I don't want to, whether principle of res judicata, constructive res judicata apply, I don't know. We are not inclined to interfere with impugned judgment, and hence special petition is dismissed.
Obliged.
Obliged.
Please manage.
We must get this listed. Notice and tag with special leave to appeal C number 17510 17571 of 2024. Notice will be served by all modes, including dusting. Notice can also be served through the counsel who had appeared for the response before the High Court.
There's a delay, my lord, in some of them from
The delay is quite substantial in almost all cases.
And these are on merits, my lord. Okay.
11 pending. My lords, while keeping the section 11 pending, the court has...
I thought section 11 should have been allowed.
No, Mr. Goswami, you have come up. What is your cause of action?
I have only one.
What is your cause of action?
My lords, the limited grievance.
No, what is your cause of action? There is no appointment of arbitrator. When the other side went, your revision you have accepted saying 8 will be decided. The earlier revision.
I am only aggrieved by page 5, the clause
In fact,
4.
let me put it. The order may be factually incorrect because reference to 8 is wrong. 8 has already been disposed of. The revision is pending before the High Court. So,
It has not come.
It is a remand order.
It has not come.
It is a remand order. The court has virtually, my lords. No, the first.
It's the other party who should be giving.
No, Mr. Goswami, please explain. This is a matter where.
I'm not aggrieved by your lordship.
Who went on 11?
11, the other side went.
Did he get an appointment?
No, my lord, in this.
What is the order? That the section 8 should be decided. In the earlier round, there was a revision. No, did you challenge the revision in the earlier round? No.
They had challenged High Court and that order has attained finality.
Attained finality. What is your cause of action?
Here the only point is, my lord, they
takes 10, 15, 20 minutes to break our head, Mr. Goswami.
My lord, they have permitted documents to be produced. That may run foul of 8(1) and B, my lord. Fresh documents at this stage, my lord. Only thing, my lord, if your lordship just have a look at clause 4, only one part of the order I am aggrieved. Page 5, my lord, they have permitted that the trial court shall permit the parties to examine witnesses.
Let me put it. If we are to understand this order, we'll set aside the order and appoint an arbitrator. You want that, we can do that. You want that, we can do that.
Only thing is one.
We got no difficulty.
May I only request, my lord, one observation.
No, we make an observation that the arbitrator should have been appointed in view of the contested facts.
I quite see what, my lord. Only one observation. If you permit, your lordship to permit us to raise all objections.
No, we are not saying anything. We are passing that order saying that in cases of such nature, matter should be referred to arbitration and recording aforesaid, we are dismissing your.
Your lordship may then permit us to, my lord, withdraw only if your lordship passes such order. My lord, we are disputing the whole.
In Uttarakhand lies before the district judge, and revision under 115 lies before the district judge in Uttarakhand. In fact, I'm little surprised. Why did the High Court should have taken up the writ petition along with this? And there's a mistake in the order also because it says matter is pending in the section 8. Section 8 has been decided. It's about matter pending in the
remanded. It was remanded.
The problem is that after holding that absence of the original or
section 8 is still pending.
They remanded it back.
Section 8 also is pending on a remand.
On a remand, my
Then
lord.
how
But
is
there is a finding.
And Section 8 provides specifically says it can continue.
correct 8.3?
And that there is no dispute. Only thing whether after 10 years.
Sorry, please, you want to withdraw or we take that? We going to dictate that in a case of this nature, matter should be referred to our.
My lord, I have to take what falls from your lordship, my lord.
Okay, then I'll dictate that. Right, on a matter of this nature, the issue should, in a matter of this nature where facts are in dispute with existence of the arbitration agreement, the matter should be normally referred to the arbitrator.
No, my lord, I'm not, my lord, your lordship will not. Let me withdraw the SLP, my lord, if your lordship.
So, I will task for the Commissioner seeks permission to withdraw the special leave petition. In view of the statement made, special leave petition is dismissed as withdrawn.
Deeply obliged, my lord.
May please do withdraw.
Repeatedly, and Bharti Airtel, I don't know whether you're aware of it.
Set off. I'm on the.
No, you won't get a penny, but you can seek set off.
My whole case today is only of set off. It can't be you proceed against me and my claim is extinguished and I can't take a set off.
You gone through Bharti Airtel?
I'll go through it again now that your lordships have indicated. I must have
There
given
are
it
two type of
cursory glance on a Monday. I'll go through it in more detail.
Okay, there are two types of set-offs which are permitted.
Yes.
In CIRP in that.
Yes.
Not all. Because in insolvency you're permitted several other. Insolvency set-off is also permitted. But in CIRP it was specifically raised and two types of set-offs are permitted there.
Contractual equitable. Contractual.
Contractual and equitable.
Probably only as a counterclaimant. Because
counterclaim.
You can't initiate.
And arising from the same contract.
And this is exactly that.
As a claimant you can't. Because moratorium.
Yes.
When they initiate and you go in a counterclaim.
And their initiation is also after the CRP was.
Yes, CRP after the CRP. And you are counterclaiming.
Yes. I counterclaim because they claimed in that. 178 versus 70.
Is the set off.
This returnable in the week commencing 21st of April 2025, notice to be served by all modes including Basket. It is submitted that during the course of corporate insolvency resolution process, when proceedings for recovery are made, certain kinds of set-off, that is equitable and contractual set-offs are permitted.
Malad, we are also praying for a stay of the plan because what happens today, it's not been approved. Malad, it's not been approved.
It's not been approved.
The plan has not been approved. Malad, if tomorrow the plan comes through, then their third party.
No, 1 minute, please. All that will happen is, if the plan goes through, the recovery vis-a-vis you, that amount will become.
Manoj may then say that if any action is taken on the plan is subject to the outcome of
nothing.
No, Manoj, with respect, if under the plan.
Balance of convenience is against.
Manoj, if under the plan and it has happened, if my rights are extinguished, then what set-off will I take proceeding?
No, Mr. Call, Mayor Prime Facie
under the arbitral proceeding.
Mayor Prime Facie case does not ipso facto mean that stay orders to be.
No, Manoj, nothing else, just that part.
No, Mr. Call, sorry. No.
Manoj, may only take one thing into account. Only one thing. Keeping in mind, Bharti, if tomorrow I go for a set-off, and the first thing that the claimant says is that the plan, not the plan,
the appellant will be entitled to raise the set-off in the arbitration proceeding.
Very grateful. Very grateful. Very grateful.
It will be dismissed. Dismissed the similar. of the co-accused.
Office report.
Same order as in the office note, the order passed it, and close with the office note. Connote.
Item 21, my lord. I'm appearing on behalf of the state of Kerala. I was being led by Mr. Venugopal in this matter.
Keep it on.
We can.
Tomorrow. Oh, the counter has not come.
Nobody's entered appearance, my lords, though service is complete upon both the respondents to whom notice was issued.
Yes.
My lords may keep it on any date. We can make alternate arrangements also.
As per office report, respondents have been served. Respondents 1 and 4 have been served, but there is no appearance on their behalf. Let court notice be issued to respondents 1 and 2, along with copy of this order and the earlier order. Relist in the week commencing 24th of March 2025.
Grateful. We can serve a copy on the office of the Attorney General, my lords. He normally appears in these matters.
So I don't know, but let it go because we
Very well.
the order.
I'm grateful.
I'm requesting for a passover.
What happened? Have you made the payment or no?
Payment actually, I'm for respondent number 1.
I'm for respondent number 2.
Have made the payment or no?
Lords, I don't have instructions to.
Why? Why are you paying without instructions?
When the main counsel is on her way, she.
Pardon?
The main counsel is on her way, my lords. I am also.
Passover you
want? Yes.
Yes. Well, we had circulated a letter to file counter affidavit, my lord. The respondent number 3, my lord, has been in jail, my lord, on account of an FIR lodged by the petitioner.
The response point is granted 3 weeks time to file replies to counter affidavit. Relist is a week commencing 21st of April 2025. Rejoinder, if any, within 4 weeks after service of the reply. Interim order to cut.
Your lordship may give us 4 weeks, my lord, because he's been incarcerated. There's difficulty in contacting him.
Okay, 4 weeks. 4 weeks.
Please, my lord. Please, lord.
4 weeks and 3 weeks.
Yes, my lords.
Service.
Lords, as per the office report, respondent number 1 and 2 are unserved. Respondent number 3 has been served. No counter has come on part of the respondent number 3.
You also know one is appearing. Where she could make the order. Only in the books.
Please not. This report, respondents number 1 and 2 have not been served. So the applicant will take steps for service of the said respondents within 10 days. Notices will be given thusly as well. Respondent number 3 has been served, but there is no appearance on their behalf. Next case.
Should we seek a passover led by Mr. Gaurav Agarwal is on his legs, minutes.
I'm requesting for a passover because I'm led by Mr. Gopal Shankar, and plus even otherwise, plus there is no survey.
6 and 8 are not served.
Plus
6 and 8 are not served.
6 and 8 are not served. And unless I.
We are the only contesting party before your lordship.
But for 6 I have.
They come.
No, sir.
Except where the workers. Not been served.
Six I have received instructions to appear, my lord, and file my counter affidavit. So give me 2 weeks time.
Your Lordship, I am appearing for respondent number 4, State Bank. I am also seeking time to file.
Plus, permit me to also file plus rejoinder to our
Respondent number 5, my lord. For PN2.
8. Anybody appearing for 8?
I have received instructions to appear for.
Reply.
R1. R1 my lord has filed. Yeah. Manage.
Respondent number 1. Reply filed by. It's on record.
Yes, your lordship.
Reply is filed. I couldn't find that.
In the office report.
Which page?
Office report also.
We started working now.
plus permit me to file rejoinder to the counter.
As per office report, respondent number, appearance is made on behalf of respondent number 6.
6.
Stop. However, as per office report, the respondent number 8 remains unserved. Steps for the service of the said respondent will be taken within 7 days. Notices will be given thusly as well. Respondent number 1 has filed counter affidavit. Rejoinder to the same may be filed within 4 weeks. Other respondents are given liberty to file counter affidavit within 4 weeks. Rejoinder, if any, within 4 weeks after service of the contract. Delist in the week commencing 21st of April 2020.
So grateful.
May it please, my lords. Lords, in this matter, my lords, I beg to appear for the petitioner. My lords, may I just draw your lordship's attention to
27, my lord, I appear for respondent number 2 under the new management. My friend appears.
I appear for the respondent number 1, the RP. I request some time to file a counter affidavit, my lords.
Lords, can I just make one respectful submission, my lords?
Yes.
Lords, I mean, I think the RP, it will be necessary for the RP to file a counter. So, my lords, it's certainly something I can't object to. But, my lords, may I just request, my lords, this requires an interpretation, so your lordships may set it out on an NMD, because it will require your lordships to consider section 30, subsection 2, subsection B of the IBC. There are 2 orders, my lords, in that regard. Of your lordships, my lords, in fact, in this very matter, where your lordships have noted the controversy. One is at page 344 of the paper book, and the other.
20th August order, Mr. Demand.
Yes, my lords, that's the order in this matter. My lords, when we had come to my lords previously on the 14th of May 2024, your lordships had also rendered a similar observation and sent us back, my lords, to the NCLAT. Unfortunately, the order said review. So the NCLAT took a very technical view and said, well, because the order says review is not permissible. What it actually, what we were trying to tell the NCLAT was that it's actually a recall application. We've been permitted to file an application to recall the previous order. But so whatever it is, it's now there before my lords. Your lordships, my lords, can now consider the issue.
Let her file the reply.
Because the resolution plan approval application has attained finality because appeal was filed with delay, dismissed, and civil appeal before your lordships withdrawn.
At the request of counsel for the respondent, pray for and grant in 3 weeks' time file reply. Relist in the week commencing 1st of April 2025. Rejoinder, if any, will be filed within 3 weeks after service of the reply.
Maybe apportionment. I'm deeply obliged, my lords.
Maybe the only issue, in fact, my lord, the slight grey area will assist your lordship next time.
I'm deeply grateful, my lords.
28 in 28.1, my lord, 2 appeals, my lord, and being led by Mr. Tankha, senior advocate. In the meanwhile, my lord, office report also says that it's incomplete.
Service is not complete. Service is not complete.
My senior joined through VC, my lord, may kindly be given access to Mr. Vivek Tankha.
So their service is not completed, some of the respondents.
My lord, I am appearing for respondent 1. Your lordship, I am appearing for respondent 55 and 56 in item 28 and 56 and 55.
Harvard has, nobody has filed counter.
We just entered appearance, my lord. We are taking time to file a counter. Please, your lordship, will file.
Who are unserved?
My lord, 12 in appeal number 1, my lord, and 25 in second appeal, my lord.
In second.
Different appeals, different number.
Okay.
27 and 77.
Some of the responses are unserved. Yeah. Applicant will take split for service of the unserved respondents within 10 days, if required by filing fresh addresses. So the notices will be given thusly as well. Next paragraph. Respondents are permitted to file reply within 3 weeks, rejoinder if any, within 3 weeks after service of the reply.
Well, at the interim order to continue.
Interim order to continue.
Great.
Your lordship would request for vacating this to your lordship.
Why?
Because your
File
lordship,
your reply.
we have not filed reply.
Fine.
Your lordship, only one request. In terms of the last order, in the last order it was said that they will maintain the accounts of the sand which is being extracted from the stock by your lordship. Please, they may file the status report also. It will assist your lordship to.
Relist in the week commencing 1st of April. That's fine.
Last order, your lordship.
Material counts of material removed from stockpile. The applicant will file status report. In terms of the last order with regard to the material removed from the stockpile within a period of 8 weeks, within a period of 6 weeks from today.
We'll file it along with our rejoinder account.
No, you file it separately.
Very well.
13.
Do that for.
13.
Obliged.
Grateful, your lordship.
Oh, straight. 14, yes.
Item 13.
Right, that 2010 judgment says that the certificates issued by this society are not to be recognized. But now after 14 years, should we interfere?
Except for the period before the High Court. I think she had worked throughout, your rival.
The postmaster, I will have to check that whether she worked or not, my lords.
She worked. She had worked 2010, 2024 March judgment of the tribunal.
I'm sorry.
You are maybe right also that 2010 judgment will override because the circular itself was washed away. Everybody must be relying upon that circular of 2007, and therefore that 2010 judgment of this court says that the society cannot do it. But one correction, let me put it. We have the state boards, we have the Central Board of Secondary Education. We also have ICIC.
May I just place
the ICIC is a society, but that's very, very well recognized.
I quite see that, my lord, but may I just place the advertisement, my lord, at page 48.
The qualification was board, my lord. My lord, you have not moved on, my lord. She is not qualified with great respect, my lord, if I may say that, my lord. The qualification says, my lord, educational qualification.
No, look, we are not going into that question. One is, whether rule will prevail or the advertisement will prevail. The rule will prevail, certainly they are right on that. As far as equivalence is concerned, 2010 judgment says it's not to be recognized. But 2007, the circular said it should be recognized for some time till we decide about it. Obviously, no decision would be being taken because in 2010, as the Supreme Court judgment came, there is no question of any decision. But after so many years, why should we interfere now? Leave it now. In any case, you won't get the job. Let me put it. After
Let me try my luck, lords, if I can say that, my lord. As your lordship pleases.
You're not inclined to interfere with it.
As your lordship pleases.
And hence, especially petitioners, the question of law is left open.
I'm so deeply obliged, lords.
This is an application under 11.6 minutes.
It's from police and the determined in the week commencing 29th or make it earlier. 14th of April 2025. Notice will be served by all modes, including.
I'm so grateful. It's deeply pleasure.
My lord, it's a very short issue, my lord. What should be the date from which I...
1 minute, please. Just 1 minute.
I'm sorry.
Come to your circular.
Yes, ma'am.
Is it a case of promotion or direct recruitment? Should be. No. Circular. Let's come to page 32.
Yes, my lord. Para 6. Yes, my lord. Not more than 3 chances will be given to a candidate to appear in the test. However, as a special case, DGITBP may permit deserving candidates to avail more than 3 chances.
So in this case, because of some reason, he has given them that.
It was given. The question is, my lords, if he has cleared it later. Now, retrospectively, he can't...
No, there was a difficulty also.
Yes.
The difficulty was because they were not being earlier given a chance to appear.
Those cases are different, my lords. In those cases, actually, on which...
No, 1 minute. When did he appear? When he was eligible?
Yes.
When was the 12-year period, 10-year period completed?
Yes. 91, 94 and 2000, he availed 3 chances.
1 minute. When was the 10-year period over?
The 12 years period, my lords, for the first time, the ACP came in 1999, August 1999.
When was that period over then?
Yes, he has actually completed, my lords, 12 years prior to that. Because he was in 79.
And was he given that opportunity?
Yes, 91, 94, he was given that opportunity.
When did the 12-year period get over?
Then 92 he got over because 79 he was appointed.
92 he got over.
Yes.
And when did he appear?
91 he appeared, he failed. 94 he appeared, he failed. Then 2000 he appeared, he failed. Then a special chance was given to him in 2002 and that time he cleared.
All others have been given only from the date of clearance.
From the date of clearance. That's a point. Actually, from the date of clearance, they are eligible, they have been given. Now, what the High Court does is, the High Court says, based upon the previous judgment, you please give that. Now, the previous judgments are distinguishable for the simple reason. Those are the cases where actually the petitioners were not given the opportunity to appear for the examination. Therefore, the High Court said that you have not given the opportunity. Therefore, you cannot hold that against them. That's why actually, my lords, the High Court directed them, you please give it from August 99 when the ACP scheme had come in. But that is not the case here. And when we moved the review petition...
The ACP scheme came in 1996.
99.
August
99.
Till 1999, he had therefore appeared in 3 chances.
2 chances.
No, 90,
91, 94,
and
and
2000
then
was later.
2000 also.
Yes, what do you say?
Initially, there was a policy which came in 1985. There was no limitation of any attempts in that. This policy came in the year 2000 and they have not raised that policy.
No, the policy till 2000, there was no policy. This requirement of 3 chances was not there.
There was no policy. They can appear and much time they can appear. This policy came into effect in the year 2000.
No, but then also there was a requirement that you had to clear the exam.
Yes, Lord.
Even at that time, there was a requirement that you have to clear the exam.
Yes, Lord. As per the
So 1 minute. So even if their 3 attempt clause be ignored, 3 attempt clause be ignored because this policy of 3 attempts came in 2002.
Yes.
But you had to clear the exam. So till you cleared the exam in 2000, you could not have been given benefit of the ACP.
Lordship, as per the 1985 policy, they were supposed to hold the exam twice a year, in February as well in August. The exam which they held was in 1998. After the 1998, they did not hold exam for 99. Then again, it was not held for 2000. Then the next policy came into effect and it was held thereafter, Lordship. So we were not given sufficient opportunities to appear. And after the 2000, the earlier policy was superseded in 2000. And from 2000, we should have been given 3 chances.
No, but therefore the issue only over here is from which state you should get the ACP, 2002 or 2000?
Yes, Lord. From the issue here is whether I should get the first ACP from the time I completed 12 years or from the time I cleared my attempt. So the only issue is this.
Look, you could not have been given a benefit of ACP in 1999 because you're not cleared the exam. You had already appeared twice in 1991 and 1994.
There are 4 respondents in this matter, Lordship. I can show the chart as per their appearance. In Lordship, can you have a look at page 99, Lordship?
How many people are involved?
4.
And are there other cases of similar nature?
Yes, there are multiple cases, Lordship. Even in 2023, even in 2024, they have given benefit from the time they completed 12 years, Lordship. And there are other cases which I can show from the self-period. I'm seeking parity with them only, Lordship.
You in your counter say that you did not, because of not holding of the exams, you did not have the opportunity to appear in the exam.
That's not the case. That's not the case.
Have you filed any leading to that effect?
I filed the policy along with my contract of 1985 policy. They have not produced that along with the self-period, Lordship.
And did you say in your counter that they were not holding exams regularly?
Counter affidavit, Lordship, they have alleged that they seek a parity and the parity has not been.
Others have been all granted the same benefit.
Others have been granted.
No, they have given a chart at page 39, PDF 39. A chart in the synopsis.
Yes.
Saying that they have only been given from the dates they cleared the exam. Whoever didn't clear it within 3 under 12 years.
Yes, ma'am. That's the correct position also. That's the correct.
They will issue notice, let's say. Are you still working?
Yes, one, Lordship, respondent number 1 has died in 2021 itself, but they have not made the alert, so the respondent number has.
I do not know, my lords. This is the news.
And one more.
I'll check up, my lords. In case if he has died, we will bring on the ALRs on record.
Hey, Jeff, you have cut and pasted the opinion given by the ASG.
My lords, in fact, my lords, the synopsis, I was going to make that request, my lord. The file which went to the ASG for opinion, they have just extracted.
A chance may be taken to settle the issue.
Settle the issue. My lords, in fact, the synopsis starts with this. The department has referred the file. That's how actually, my lords, I was going to make that. We'll correct the, my lords. We'll correct this.
One more thing. Lordship, as per they have challenged.
It's delay of 900 days.
That is because
of the review.
Review.
Almost 5 years in this matter.
No, case review was pending.
Review was pending. 54
days. Has been decided.
Should have got it.
It's based on merit, not on by a short cryptic order. It's by a detailed order.
Take time to file a counter.
issue notice returnable for week commencing 28th of April 2025. Notice will be served by all boards, including Nasi. Notice accepted on behalf of
Respondent number 2 to 4.
2 to 4. It is stated that the first respondent had expired way back in 2021. The respondent will take further petition. Will take steps in accordance with law to bring on record the legal representatives of the first respondent. Counter affidavits may be filed within 4 weeks to join the referee within 4 weeks after service of the counter.
And it's permission to correct the synopsis.
Permission is also great. You have to correct the synopsis.
Obligement.
Reminded of my
Obligement.
Don't.
May it please, my lords. Yes, my lords. Against the order of the High Court,
before the tribunal.
we succeed.
The tribunal, they don't file any claim statement and you knocked off.
But I must tell you, you are fortunate in your first writ, unless it's some certain undisputed writs.
All that was said was you can't. Also, contrary to it's contrary to law, because what it says is direction to payment cannot be issued. But you'll have to file, they'll have to file a claim statement. They're living under the impression we don't have to initiate anything, we can decide.
Go to the superintendent and get it.
And my lords, there has to be adjudication. The
You haven't got anything from 14, you're running around.
I know. Issue notice returnable in the week commencing 21st of April 2025. Notice to be served by all modes, including Glasgow. It is submitted that the petitioner had filed a writ petition for enforcement of the order passed by the tribunal dated 11/9/2023. Stop. There are earlier orders of the High Court in favor of the. There is an earlier order of the High Court in favor of the petitioner. Impute judgment overlooks the said position.
Would your lordship consider a stay, my lords, of the
What stay?
Of the High Court's order, my lords?
There is no stay. What stay is going to do? When the stay, the order doesn't say anything.
But my lords, the problem is that they have collected the money.
If you
Despite
succeed,
your lordships confirming the High Court order, they don't return
just
to the superintendent.
You just go through the judgments because they have withholding clauses in almost all government contracts, early government contracts. If I'm not mistaken, Kamanullah or something, there's a detailed judgment dealing with it that says what can be directed by way of interim order by the courts. You have the judgment.
Yes, my lords, I also have the judgment, my lords, which says that there has to be adjudication.
That's correct. No, that's correct.
73 of the
contract. No, that the department doesn't believe.
Yes.
It's the correct one.
Yes.
But there is a judgment dealing with what directions can be issued, because the arbitrator cannot go into disputes in the other contract.
Yes. This is it, my lords. I bow down. This is it.
He cannot go into the questions of disputes in the other contract.
In a third unrelated contract. Yes, my
So
lord.
all that can be done. And there's a term in this contract which says if there are disputes in another contract, they're entitled to withhold. That's a problem.
That's the problem.
Because
you have a writ. You have a writ which can only be neutralized by an adjudicated proceeding.
Yes, my lords.
And he can't go to the superintendent and get an order.
He cannot, my lords. He's not an adjudicatory forum. And it must be an adjudicatory.
You'll have to tell them to go to adjudication.
My lord.
That's it.
My lord. Very well. I'll follow up on this line of cases also. I'm grateful, my lords. Very grateful. Grateful.
So look, normally a show cause notice should not be interfered with.
Two exceptions. But the High Court itself notes at page 10 that the facts are not in dispute.
No, but you say in your benefit, They also comment on the merits. They should not have commented
Yes.
on the merits.
But second thing, my lord, the High Court does is it disagrees with the view taken by the Karnataka High Court, but applies the reasoning of the Karnataka High Court to me to say that the annuities collected by me must be shown to be in lieu of toll. Karnataka High Court, my lord, notes the agenda item correctly. Lord, see page 735 only for a minute. Which is part of the...
You raise it before the authority will just clarify the find observations on merits are not mine. You raise it before the authority, let it be sorted out there.
Right. But I'll make one final effort, otherwise I'll rest with what your lordships indicated. My lord, because my lord, they wanted to provide exemption for tolls initially, they realized some people are not collecting toll, they are being paid annuities instead of toll. 735 is an agenda item of the GST Council which notes that they are similarly placed as people who are collecting toll, therefore they must be granted exemption. So, my lord, now 2009 I complete the highway.
But you may have a point. We are not saying you don't have a point. But it's a factual dispute at the first stage, whether the NAT will fall into the first category, that is equivalent, or it was a substitution of the toll, or was it in with regard to construction of the road?
My lord, only one caveat and I'll stop with that. My lord, the exemption that has been granted, it is worded to say, my lord, that if an annuity is being granted, that is sufficient.
No. It's an annuity that should be in substitution of the toll.
No, my lords. Page 695.
That's the object behind that. That's the object behind.
No, my lord. In
Look,
fact,
there are two ways.
Yes.
When you have spent the money, you can get the toll to recoup your money.
Correct.
And make your profit.
Correct.
The other is because if the NHAI does not permit you to collect toll, they'll pay you anything so that you can recoup your money and make your profit.
Your lordships are right.
But the third is where the construction itself, when you make the undertake the construction itself, then there is no exemption as such. While undertaking
my lords
construction.
My lords have put the three categories perfectly. Now, my lord, the second category falls in that species where I will be paid annuity so long as I am maintaining the highway and giving access, my lord, to the authority or anyone who's passing. The third category is a pure construction contract. My lord, the error the High Court makes, that's why I'm trying to, my lord, just caution your lordships is, the High Court says the exemption must be for annuity which must be shown to be in lieu of toll. My lord, when I enter, I either get the downside or the upside if I'm...
We clarify, none of the observations will be made.
Yes.
We just clarify because normally when you out somebody on the ground that we are not excising or entertaining the writ petition, then observation on merits will have its own consequence.
It's also a 57-page, my lord.
No, there are some observation. Initially, they are observations on merit.
Yes.
Then they go on to the entry number. So that will not be mine.
Right.
The interpretation of the three circulars, etc., or entries will not be mine.
Right.
It is pointed out there is a conflict of opinion on the merits, as noticed in the impugned judgment. It's an opinion by High Courts on merits, as is noticed in the impugned judgment itself. However, we are not inclined to go into the said aspect, as we feel that in the present case, the issue should not have been obtained. So, in fact, the impugned judgment in the later portion, the courts have set up the said finding. So, in view of the above, while we are not inclined to entertain the present special petition, we make it clear that the observations in the impugned judgments on merits would not be treated as final and binding. So all issues and contentions are left, or merits are left open to be raised and determined during the course of adjudication.
But including on the circulars applicability.
Including on the circulars.
Grateful. I'm grateful.
Another way. In my order is mentioned there as a judge of the.
He is in, you are in 35, or you are also in 38?
No, 38, I'm sorry.
This will go before another bench. My order is different.
No, my lord, your lordship's order will not have any bearing on this. That was in a matter. In Vikram's case, all that your lordship said therein was that any sale which had taken place before RBI's prohibition came into being is not impacted. Today, the question is that a person who's the ex-management has not let the liquidation proceedings go on for 30 years. The official liquidator is not concerned. No one else is concerned. Filing appeals.
Maintainability.
The fact that a sale is valid or not having taken place in Vikram, which was your lordship's judgment as your lordship's then was.
Millards, Vikram's case, Millards, is completely different, Millards.
Precisely.
Because in that case, Millards,
Vikram has no bearing on this matter.
Except saying the circular of the RBI came on 9/4/1997.
Today the
In that case,
management,
everything was done after that.
Today the management, 30 years you don't let the liquidation proceedings go on, but you keep filing petitions after petitions here against someone who's legitimately got the shares. And concurrent findings in my favor of the
ex-management.
He's the ex-management. Now they
Goyal has accepted. Company is not liquidation.
Goyal has accepted the
Company is not liquidation. It is the court has appointed a liquidator, my lords, as provisionally. As per law, my lords, once a winding up action is taken, even that the management continues subject to.
No, but
the
his
rules
case,
of the liquidator.
Look, that's why I didn't want to hear it. Because if the shares were transferred prior to that,
That's not correct, but that's not the correct position. In fact, interestingly, he says that I purchased the share from one Vidyasagar. And I lodged on 12th of April 97. But Vidyasagar purchased subsequently.
No, lodging is something different because we have always recognized equitable interest.
The AG Vidyasagar purchased. He is not before my lord.
He
said I
purchased maintainable.
under
You have no
April.
And the
How could he have shares to lodge? How could he have shares to lodge? Well, it's also in any case, this is a
To be listed before
your lordship in all humility, why?
Chief, his name is mentioned. I also.
to be presided over by Honorable Mr. Justice Cook.
Very great.
It earlier passed that demand order.
That's right. Very grateful. Yes.
In the week,
That's the
saying
meanwhile, it's the
3rd of February 2025.
But there was an order all throughout, my lords.
No, there's no interest. There's no interest. What are you saying, my lord? Yes.
Nothing.
Grateful. If they've got the shares transferred, they should not sell those shares.
1 minute's coming up after 2 weeks.
Yes, grateful.
Huh?
Passover sort for me, your lordship mentioned recruitment.
We are not recording.
No, I'm 38, but I'm saying just let
Let
it
it come
not
up
be alienated until that level. Shares
No,
will
no,
vanish.
no.
Shares will vanish.
No. We are not, nothing will vanish. For so long they have not vanished.
They were like safe in the oil well, that's why they didn't vanish.
Wait, please.
Yes, please.
The High Court interferes against an ad interim order under Section 9. 9 is still pending. But I am the owner, I have to get a particular share. How does the High Court interfere?
You can't stay there long.
No, just turn to the.
Your claim is monetary claim and balance of convenience, etc.
Will kindly appreciate. I am the owner.
Irreparable harm and vanish. He's obviously constructed it, so let it be.
Milord, with great respect, if I am the owner, I have to get a larger share, 65%. We have to build 2 towers.
You'll get your money. Get your money. Don't stay. This is like.
Why should the High Court interfere in an appeal against an interim order?
No, but then the interim order.
Section 9 do.
That interim order passes also odd. They have two options. Let me put it this court judgment said two things. When an ex parte interim order is passed, you have two options. Either file.
It was not ex parte. There was a detailed detailed.
I went through the order.
There was a detailed interim order pending, my lord, decision of section 9. Kindly appreciate. Kindly appreciate that. Kindly
we are not inclined to interfere with the impugned judgment and hence specially petition is dismissed. We have clarified the impugned judgment and dismissal of specially petition will not be treated as expression of opinion or merits. So it will be open to the petitioner to raise all pleas and complaints before the court where petitioner where the application is section 9. And 9 is pending. 9 of the Arbitration Conciliation Act is pending. Full stop.
Without being influenced by this order, Lord.
Justice. It will be open to the state court to balance out equities. That would say.
Without being influenced by the High Court order.
No. They're not saying anything. On balance of convenience, they're absolutely right. Balance of convenience.
Apart from
no.
The merits of the matter,
no. On balance convenience, they're absolutely right.
Not on the balance, my lord. About, my lord, the construction, etc.
No, please. Your amount of change in stance you have taken, but there are certain equities. If you want certain things to be done by them, you can ask for that. Therefore, I said, if you want certain things, obligations, they have to.
Your cases, they are not cooperating and rendering the commercial tower non-functional.
Yes, but it's completely not.
So that you can get that.
Yes.
Get that direction. That was the object.
Direction.
Yeah.
That is the reason why
they have to sign it.
That is the reason why we refer to that. Not because we wanted to change the view expressed here.
Item 41.
Arvind Kejriwal.
Same order in the light of that Arvind Kejriwal said.
Yes, we take an instruction.
Lordship, on Friday, you had put to me a question about the amount there, Lordship. So when I spoke to the client, Lordship, he handed me over one order, Lordship, that was not part of the counter, Lordship. This was the decree order. You had asked me how we are coming to that particular amount.
1 minute, please. 300 rupees a day cannot be.
It's not 300, Lordship. Can I hand these? This was filed on Friday, Saturday, Your Lordship.
So how much is the amount?
The amount that the decree order had said by the civil judge was, Lordship, 74,50,000, Your Lordship. Your Lordship, at least can I show you the orders?
No, please, it's not possible. It's not possible. It's not possible because the vehicle has to be given to you. That's all.
Lordship, may just hand over the decree.
No, please. Then we are admitting this. That's why we asked to take instructions.
Yes,
don't be greedy. Don't be greedy.
No.
In a case where they have sold the vehicle because the amount is certainly dues payable by you. There were certainly dues payable by you, checks bounced. Maybe the amount payable was about 75,000. They've sold the vehicle. We said we'll get you the price of the vehicle as on today's date. So please take that 12 lakhs. That will be fair.
Give me some concession, increase little more, Lordship.
When did you pay the balance amount? They never, as per the decree 94, page 94, you had to pay the balance amount first.
Yes, Your Lordship.
Did you pay it?
I'm sorry, Your Lordship. 94, Your Lordship. Of the SLP, Your Lordship?
Yes.
The orders.
This is the preliminary decree.
Lordship. I'm sorry.
You didn't pay the amount.
I'm sorry, I'm not instructed on
Without that, where is the question of they being liable to pay you anything? The first step is to be taken by you.
Yes, Your Lordship.
If you didn't pay the amount, then there's no question.
The amount of 60,000 was supposed to be paid by
you also. How can you ask it? You take that 12 lakh over.
Lordship, just give me another day. I'll come back tomorrow.
No, please. We gave you
Lordship, I'm not able to answer justice.
Forget it. It's impossible. You can't get that much amount on one vehicle becoming 74 lakhs. Please.
No, and I'm not even coming to that amount, Your Lordship.
And,
just one
and today, fortunately, prices of vehicles have not risen the way interest has risen.
Lordship, just one small indulgence, Lordship. Just one last.
Appearing for the petitioner.
We actually served it also, Lordship. We sent an email of the decree because my Lordship had put a question as to why are you.
Your suit itself was filed after they sold the vehicle. Where is the question of returning the vehicle to you? The decree was unworkable from the word go.
Livelihood with the time he sees.
No, please.
The decree is to return the vehicle to you, not even give you the money for
to take the vehicle out.
That's the
right now.
We
are just asking to take that 12 lakh of rupees.
Lordship, enhance a little more. No, consider.
No, please. That's equitable. Don't be so wrong. That's wrong. Absolutely wrong.
Just some indulgence to show here.
If we are giving you indulgence. Right up. Facts of the case are rather peculiar. It is rather peculiar and date back to the year 1994. Stop the respondent. Respondent or the?
I am the respondent.
No, or somebody else. Your predecessors had taken the loan.
No. It was my husband.
The respondent number 1, Rajeshwari Mohanty, had taken loan from finance of rupees 2,57,520 from Consortium Finance and Leasing Limited for purchase of a vehicle. The amount was payable in equal monthly installments spanning over 36 months. Some payments were made, but check for amount of rupees 63,375 was distorted. The first respondent was prosecuted under the provisions of 138 of the negotiable instruments. Like what happened in that?
That was the decree order, Lordship, that we want to show. That was the problem when I took
138 order. Check bounce case.
Plus, cut off the portion with regard to the check bounce case.
Yes. 52.
To stop. It is also apparent that the Consortium Finance and Leasing Limited took possession of the vehicle and had sold the same towards recovery of their dues. Next page. The first respondent in November 1999 filed a civil suit for recovery of possession of the vehicle and other reliefs, including damages for rupees 1,54,500. Stop. The proceedings continued for over a period of time, resulting in passing of the preliminary degree when?
Decree was on the district 24/12/2005, Your Lordship.
24/12/2005,
Your Lordship.
24/12/2005.
Signed in decree 7th January.
This was followed by the final degree dated
7th January 2006.
To 7th January 2006.
Yes.
6.
Yes.
Which page is the degree?
Decree as such, page
90, Your Lordship.
95. No objection filed. Decree is sealed and signed.
Okay, the preliminary degree. Which page is the preliminary degree?
It starts.
94.
Starts at page 83, Your Lordship.
The preliminary degree. That degree has passed. The operative portion of the judgment, preliminary degree, states that the appellate, that the leasing company The operative portion of the preliminary degree of the judgment of the judgment dated 24th December 2005 directs the first respondent to pay the amounts as per the hire purchase agreement within 2 months, and thereupon the finance company shall release the seized vehicle and pay a sum of rupees 1,54,000 within 2 months. Expected 70% fine. It may be noted that that Mrs. Consortium Finance Leasing Limited had got merged with Messrs. Poonawalla, Magna Leasing Company, and subsequently with Poonawalla FinCorp Limited. Poonawalla FinCorp is a change in name or is
amalgamation that happened.
So change your name, Lordship. Amalgamation or name change?
No,
The name change, Lordship. Name change, Lordship.
Name change, it's an amalgamation.
Which was and was subsequently known as Poonawalla FinCorp Limited. Explain. By order dated 13/9/2024, I issued notice, the notice of facts, and had also directed the appellant Poonawalla FinCorp Limited to deposit rupees 12 lakhs in the registry of this court. Next paragraph. We have noticed the facts of the present case, some briefly noticed the facts of the present case, and as we feel that its litigation has continued for far long and must be brought to stop. Hence, excising upon the Article 142 of the Constitution, we direct that rupees 12 lakhs along with interest accrued thereon, with no interest, 12 lakhs deposited by the applicant will be paid the first upon Rajeshwar Mohanty by the registry of this court. So upon the said deposit being made, proceedings be treated as closed.
One just kind consideration to enhance a little, Your Lordship, because the mind stuff, that's all. I'm just putting it last.
So 12 lakhs I thought was sufficient. It's why you are at default because you did not pay the money.
Yes, Your Lordship, I didn't pay.
You didn't pay the money.
I didn't pay that 60,000.
So, really speaking, the degree even today is not enforceable. Because when you pay the money, then the degree would have been enforceable.
No, that would be make sure that
it was a conditional degree.
No, of course, I understand.
Sorry.
I'm just asking for Lordship.
The degree being the aforesaid degree was conditional, and it is accepted that the first respondent did not pay the said amount. 12 lakhs is sufficient.
Obliged, Lordship.
That's here, your lordships have issued notice in the contempt. One of the respondents.
What is the position? Have you paid the money or no?
So, the condition is this, that we've been in constant communication with the other side. There is a problem that has arisen, which is the bank account of the partnership firm. There is a new partnership that got constituted upon the death of the father of the alleged contemptor number 2. And the brother has not been cooperating in getting the bank account revived. The money is up to 48 lakhs is lying there. They are willing to arrange the balance, which is 1.02 crores, to make that payment.
The person has died who had signed the agreement.
No, he is alive. They're both alive. But after the death of the father, because the partnership firm was between, so the petitioner herein is his older brother who has passed away. His 2 sons now have taken over the partnership firm. They had to make this payment of 1.50 crores to this the petitioner's HUF. the payment had to go via the partnership firm upon the death of the father, alleged contemptor's father. The bank account has sort of frozen in a manner because the new partnership deed is not being placed on record, not because of my doing, but because of my younger brother's doing, who's also alleged contemptor here.
Yes.
There is 48 lakhs lying in the bank account.
He's also, you are paying for him. Why did you help out this?
The payment had to be made, Manoj. The settlement, Manoj, may have page 32 of the.
But he's.
No,
the payment had to be
all
made
of this is not
exclusively
relevant. It said that you pay me, you can get it from your partner.
You pay up the amount. Look,
Page 29
there is something between interest. That's for you to sort it out.
Yes, Milot. After 10 months, Milot, my learned friend did. Sorry.
It's for you to sort it out and to see if he's not agreeing with that mode of payment. You find another mode of payment.
Milot, my problem is 48 lakhs, which is.
Look, now we're going to direct that 1.5 will now carry interest.
Yes, Milot, absolutely.
That is the only way to make you work.
Milot, may allow us. We've been in constant communication.
If you don't make it payment within 15 days, we're going to direct interest from the date it was payable till the payment is made.
Milot, may allow 30 days, Milot, because the bank account also has to be open, Milot.
Whatever it is, that's your headache. Not his concern. And your internal disputes are not his concern.
Milot, I bow down to that. I'm just requesting Milot may give us 30 days.
Okay, but if you don't do it within 30 days, then you're liable to pay interest at the rate of 12%.
Milot may consider.
That's not fair.
Let your lordship may fix a date. Let him come with a demand draft of 1.5 Milot. It's been 1 year. And the second part is a plot.
The appearance is made on behalf of
Rakesh Goyal, Milot. He's respondent number 2.
It's Rakesh Goyal.
Yes, Milot.
With a request that some more time may be given for making payment. Both of them.
Milot, page 29, clause 1.1.
Yes.
It's only Rakesh Goyal.
It's only Rakesh Goyal.
Both of you are not.
No, Milot, sir. Payment for Rakesh Goyal, plot has to be transferred by both of them.
Having misread.
29. Manoj, may I have page 29 of the settlement agreement? It is on record, Manoj.
Page 29.
Page 29, Manoj.
1.1.
Clause 1.1, Manoj.
Within a period of 60 days from the date of execution of the.
We had extended that time.
Yes, Milot, lordships had. So they became April, Milot. So 9 months.
Rakesh Goyal shall arrange on behalf of the firm. Milot, I am willing.
Whatever it is.
It has to go on behalf of the firm.
1 minute, please. Whatever it is, both of you have to make payment. Otherwise, we'll impose the interest on both of you.
Manoj may just have that. Manoj, the payment
Which
had
page?
to be
Which page is
page
clause?
29, clause 1.1, Manoj. My obligation is at clause 1.3.
Within a period of 60 days from the date of execution of business, Rakesh will arrange payment of rupees so on behalf of the firm. Look, you have taken the obligation. If you have any dispute with regard to the firm, you have to comply with it. You may have a litigation against him, and that interest which you are imposing, you can claim from it.
No, that
Milot, my problem is, Milot,
that's also mentioned here only, Manoj. In the
a substantial portion of the money is lying in the account of the firm, Milot.
Unconditionally entitled to get back.
You have to make payment to him. He's not concerned with the interstate dispute.
Please, Manoj. So, Manoj.
And as far as the plot is concerned, what's
Manoj, as far as the plot is concerned, Manoj, that obligation is on me, Manoj, at para 1.3, Manoj. The physical possession, Manoj, they can take even today, but the difficulty is that there are certain user charges, Manoj, about 1.5 odd crores, Manoj. So for that, there's a petition which is pending. That's my instruction, Manoj.
Please execute that agreement with the.
And he must clear those. It says without encumbrance. If he succeeds, I will subrogate the rights to him if he wants. I have no difficulty, but he can't.
Manoj, what I can give today right now is, Manoj, the obligation was twofold. One is to give physical possession. Two is to execute the deed. Manoj, I'm ready to do both.
So am I.
Manoj, as far as my obligation is, so Manoj, there were 3 parts of the obligation.
You can't enjoy the deed benefits of the settlement and not comply with the terms.
What? So there were 3.
Otherwise, we got to cancel the settlement.
Yes.
If you want, we can just simply cancel the.
Manoj, Manoj, there were threefold obligations under clause 1.1. It was respondent number 1 who had to pay 1.5 crores. For that, Manoj, I am not concerned. Manoj, as per 1.3, I had to give physical possession of the property and also execute the deeds. I am ready and willing to come forward and execute the deed, Manoj. He may do the.
You have to get the NOC. You have to get
Manoj, for that, Manoj, that the problem is that
no,
there is a.
You can't help it. You have to, please. You pay the amount.
Amount to be paid by.
1 minute, please. You pay the amount under protest with the authorities, get it, you fight out that litigation.
Manoj, let me then for that, as far as that aspect is concerned, let me just seek instruction because I'm just entering appearance today, Manoj. I am, as far as physical possession is concerned, I have
right now.
Also, even the alleged contender number 2 is ready and willing to hand over physical possession. This is the only.
1 minute, please.
And Manoj, para 1.6.
I'm going to record that.
And para 1.6 was the obligation on the petitioner, Manoj. So,
yeah, the first we have to
clause
1.6 is what?
Well, subject to these two, I will relinquish all my rights on the 6 properties. We were all partners. I said, you give me this one property, give me 1.5 crores, and I'm done.
Okay, should we refer it to the mediator who had settled it?
Because what? Because this is just by contempt is filed. Lordship's issues notice.
1 minute, please.
1.5.
Because this intricacies can be worked out. What was
just delaying, Milos? 1.5 crores is unconditional, Milos.
There was a mediator, we were not.
It was before the mediation.
See the opening line of the Chief Justice's order.
Because but 1.5 crores, I am saying let them at least give that 1.5 crores. This land we can mediate, Milos.
We have, look, contempt as income may not be maintainable, but we wanted matter to be sorted out. We said refer it to mediation, let it be sorted out.
Because after mediation, it is agreed I'll get 1.5.
I know that. This working out will also require a little bit of mistake.
Because this is just a red herring. The clauses were very clear when we entered. We sat for hours on this, Milos, that you can take from your firm, you give me 1.5 crores. Now this happened in March of 24. We are in January of 25, Milos.
The second respondent, Rakesh Goyal, will ensure that payment of rupees 1.5 crores in terms of paragraph 1.1 of the settlement agreement was made.
But I need assistance from this.
1 minute, please. It's made within a period of 1 month from today. If required, full stop. It is his obligation to make the said payment. And if required, take assistance or help from third parties. Full stop. In case payment is not made, the court may be compelled to direct payment of interest.
Gratefully.
From the date of default till payment is made. Expect. Direct transfer of payment for the first
Sanjiv Goyal,
first and second respondent Sanjiv Goyal and
Rakesh Goyal,
saying that they are ready and willing to give physical possession of plot number
47 and 48, phase 6,
32 minutes. Page 32, 4th line.
Plot number 37,
47 and 48.
47 and 48.
Phase
6.
Focal point, Ludhiana.
Phase 6. Focal point, Ludhiana.
At measuring 6,200 square.
To the petitioner. Stop. However, that's how there are certain views which have been raised with regard to which there is litigation. Stop.
Mediator contact.
The response 1 and 2 will ensure compliance of paragraph 1.3 within a period of 30 days from today by executing the said documents. Expect.
Kara said 1.6 is the consequent obligation.
Once the said documents are once the said compliances are made, the petitioner shall abide by and comply with paragraph 1.6 of the settlement agreement.
Grateful. Lordship may adjourn it by 6 weeks, Milos, because this has taken 1 year, Milos. With great difficulty, Lordships heard us for an hour that day. Then Lordships have passed an order because there was another claim by a third party. Lordships will recollect. One daughter saying something. So with great difficulty, Lordship may ensure it is done so that I also comply with it.
The value of the properties is much more.
Much more, yes, Milos. Absolutely, Milos.
So you'll have to somehow find the money and get your new property.
Yes, Milos.
Your back, whatever has happened in the past can be only got, you can get rid of it. You'll have to find some sources for it.
Well, my client is 76. He wants it to be to get rid of, otherwise you inherit litigation only. Milos.
After 20. 17th of March.
Milods, grateful to you. I'm obliged. Very great.
Sorry. You are here? It is covered by Lord's judgment. It's 7 days bench judgment.
Yes, how is this judgment sustainable?
Can I indicate what has happened, Milods? Just give me 5 minutes, Milods. We are a company, we issue a LOI for certain services in March. Because that LOI is at page 1, just have at LOI, Milods. Give me 5 minutes. And it is how it's an abuse of process by asking for an arbitrator. Because I think one of the grossest abuse. Page 114 is an LOI. I will give him services. We will enter into an agreement because there's no MOU. There's no MOU. And sorry.
Correct, we are aware of that.
Yes,
but it's also a fact that he continued to work for 9 months.
Yes, and we paid him for that.
But now the issue has to be resolved.
No, there's no issue for these 9 months. Can I say what he's done? That's why I was saying the great gross abuse. Can I please give me 5 minutes? March 22, I have not referred to any papers. March 22 LOI, no formal agreement entered. Whatever services he has given for 9 months, we have paid him. There is no dispute about that payment. On 21st December, page 135, we said, sorry, we do not want your services anymore. 1 month notice is given. Whatever are your bills for November, December, January will be paid by Jan end and February. No difficulty with that. There was a delay of 30 days on payment of that amount. The payment is made final on 4th of March of 2023. What he does on 6th March, immediately writes a mail. Under protest, I am accepting your payments. I was coerced to accept that payment.
Not for the arbitrator.
Now, this is his demand. His demand is not for these amounts. His demand is that you should have given me 4 months notice for termination.
Agrawal, all these are points we raised before.
Because if nobody will settle disputes with us, nobody will enter into settlement.
No, this is not the way.
Because can I just indicate?
The God and satisfaction principle has to be taken.
Therefore, because please have your lordship, the prima facie something must be there.
No.
Otherwise, somebody will write a mail after.
Mr. Agrawal, we can't go into it.
Because suppose somebody is alleging coercion, somebody is in business for 22 years, we enter into a discussion.
Mr. Agrawal, in fact,
it will just be waste of money.
Mr. Patiwala is very clear. Don't go into any of this.
Therefore, Milos, please have a look at his dispute. I can understand, Milos, if dispute is something. His dispute is.
God is satisfaction is all.
Therefore, Milos, your lordships have said, if prima facie, what is the reason why?
Mr. Agrawal, we cannot go into all this.
When I would like to persuade your lordship that it's a fraudulent claim being.
Look, please. This could have been avoided instead of this appeal and the parties coming here. If it had been raised before the arbitrator, it could have been over. That's the wrong order. They granted. Sorry. They granted. Having regard to the facts and circumstances of the case and respective contentions raised by both sides, including the plea of accord and satisfaction, failure to enter into, non-entering into the memorandum of understanding, etc., are issues which have to be examined by the arbitrator. Stop. It remains undisputed that the parties had entered into the letter of interest.
Letter of intent, according to which I've come to an end. That contention also may just record it. I'll raise it before the arbitrator. I'm not saying, according to me, that letter of intent was only for 1 month.
You said any dispute arising under this LOI.
Yes, Milos.
So everything is traceable to this LOI now.
Because there's no agreement. Milos.
1 minute. Letter of intent, however, remains undisputed. So the respondent does raise the contention that it is for limited period.
Milos, that's what I said.
The effect thereof, again, is for the arbitrator to examine and consider.
Last line of the previous paragraph, previous page.
Next page. Recording the proceed, the appeal is allowed.
Lords, may clarify that the observation made on merits by the High Court.
The appeal is allowed. And the application for appeal is allowed accordingly. But the impugned judgment, according to the forms, the impugned judgment is quashed and set aside, and the appeal is allowed. Accordingly, the application under Section 11, bracket 6 of the Arbitration Conciliation Act 1996 will be treated as allowed. So, which we read for it too.
98 lakhs is the claim.
This is a claim. Both the parties are in Delhi.
In Delhi, yes, in Delhi.
This is the amount.
98 lakhs is their claim in the arbitration notice. 3 months notice period we didn't work. They said we are entitled to that 4 months notice. You have given me 1 month notice, so 3 months notice.
A retired district judge. Otherwise, I thought Justice S.P. Garg would be.
Whatever lordship, I have no. Some learned senior counsel can also be appointed. But 98 lakh claim. I'm very Lordship Justice Chandrachudi has appointed me arbitrator in 2 matters.
I don't mind that. It's based primarily a commercial matter.
Yes.
Somebody who's done work on the original side
Yes.
will be better.
Yes. So whatever your lordship says. Whatever. I have no issues with that.
Inka Guruswamy, senior advocate of this court, is appointed as the arbitrator to go into the disputes. So she filed her declaration in terms of Section 12 of the Arbitration and Conciliation Act within a period of 4 weeks, actually 2 weeks from the date. Copy of this order is received by. She'll be paid in terms of the fourth.
All contentions of
all contentions and conditions, all pleas and contentions are left open. The observations made by the High Court and in this order would not be treated as expression of opinion.
Grateful. I'm obliged. Obliged.
Your Lordship. 303.49. My Lord, may I submit, my Lord? This is a rank jumping case, and the similarly situated people are already working, and I'm out of job. My only respectful submission is still, my laws dispose of these matters. I may be permitted to work, my Lord. My Lord.
No, I didn't understand.
My Lord.
No, nothing can be done.
My Lord. My Lord, another.
This is our time to be not real argue.
Yes, you have to start now.
Yes.
30351, Lord, I have a submission. There is one lady, Anamika, who was appointed by virtue of an High Court order, and she, another lady was thrown out of that. She holds highest merit in the category, and she has been appointed, my Lord, that should not be.
No, we are going by what has been argued. We cannot go into individual cases of that nature. If we accept your plea that individual cases can be gone into, then we'll go into that. We can't otherwise.
Lord, in 303.5, Lord, in 303.5, I want to make two submissions, Lord. Brief submissions, Lord.
We have already heard all of you. We are not going to permit that.
Two brief submissions, Lord. I am representing non-tainted people who left the job and joined this service, Lord. That was one. And second, Lord, what is deliberated as if the OMR itself is not authentic, Lord. OMR is authentic. What was manipulated was the mark tabulated in the Excel sheet.
We have already argued, please. That's been already.
My IAs may be taken note, Lord.
No, we are not going into individual cases. Whatever has been argued, if they noted.
So there is only one thing I need to point out. My Lord, in a case where the single judge, my Lord, directed finding jumping in my application, my case to be considered, having been considered appointed, division bench confirms that has attained finality. There is no reason why, my Lord, that appeal can be reopened.
All these matters are heard by the division bench pursuant to order of this court. Therefore, nothing will individual cases be considered.
Please start.
My Lord, I appear in 303.8. I only want to make 1 point in 30 seconds, my Lord. Just 1 point in 30 seconds, my Lord.
Yes, please.
My Lord, if your Lordship would see paragraph 240 of the impugned judgment, the Honorable Court has gone by the percentage of tainted candidates vis-a-vis those appointed. But your Lordship will see from the written submissions of the CBI, the number of investigated candidates were the entire percentage that was that participated in this election. So to that extent, saying that 8.5% of teaching community and 14.47% of the teaching community teaching candidates were tainted may not be a fair representation, because the actual taint has to be seen vis-a-vis the number of candidates who participated. And that your Lordship will see comes to less than 2% in both cases, my Lord. That is point number one that I wanted to place.
They haven't gone into those figures.
Yes, but
they not go into those figures.
But
they only went into the figures with regard to those who had been appointed.
Yes, but that is what I wanted to say is that may not be
an
accurate.
It's not possible.
But that may not be an accurate impression, because CBI investigated everybody. Okay. The ultimate percentage is only 2% of the total who participated. That is what I'm saying.
Where do you find that?
The fact that they investigated everybody. My Lord, the fact that they investigated everybody, my Lord, your Lordship will get that from CBI's report.
How many people participated?
My Lord, the exact number is not on record, my Lord. That exercise nobody has done, my Lord. That is what I'm saying. 25. My Lord, because otherwise para 240 appears to give an impression that nearly 10% of the candidates who are appointed are tainted. But really the percentage has to be calculated vis-a-vis the whole people who participated. The fact that CBI investigated others also is coming from CBI's written submission, my Lord.
Okay.
Much grateful, my Lord.
The second point of the state, your Lordship said deferred. Your Lordship will hear it later on, my Lord.
Second point.
Lord, that's regarding, Lord, the direction number 8 at page 281 regarding the government order for supernumerary post which had been created. So there was a direction for a CBI inquiry. So
that part we'll hear you little later. That part we can hear you.
Lord, there is item 303.52, my Lord. It's a batch matter, my Lord. Saddam Hussein's matter. And we were appointed regularly by untainted people, my Lord. And
we have heard arguments excessively for 2 days from your side.
Grateful, my Lord.
303.86, my lord, it's a matter where I was put in the list, tainted list, because my B.Ed degree came later. Otherwise, I completed all the. My lord, I have filed written
The entire selection was vitiated because of malpractice sponsored by the state government. I just point out to your lordship, kindly turn to page 1167 of volume 5B. This was an application made by the School Service Commission before the Honorable High Court, seeking protection of appointments of all illegal appointees.
No, you are paying for whom?
I am paying for the original lead petitioners who are asking whether that the entire selection is bad, should be set aside. And that was the order of the division bench.
Yes, please.
Now, the
which file are you taking as a lead file? 303?
5B. Volume 5B. Volume 5B.
Volume 5B. Not being given in the template.
Whether I am referring to volume 5B, the compilation which
5 and 5A, 6 and 6.
Document 5B, something like that.
Is there
Volume 5B. Miscellaneous volume 5. Top one.
Pen drive was made by the office or by the
1171.
Last one.
Give it here. 5B is not there.
Miscellaneous. No.
Where is 5B?
Volume 5B.
This one.
6B. V followed by I is 6. If you're going to show it on this, then don't waste time.
5B.
5B. Page 1167.
So that's 6B, not 5B.
5B.
5B seems to have been added later.
5B is not there.
You have at the top miscellaneous 5B. That's not there in the pen. First one is miscellaneous 5B.
No. Well, actually, the V and B are connected to each other.
So, this is 5B, then the top.
5B.
5B, yes.
I believe bylaws have got it. Now, the state government, in a very peculiar manner, created certain new posts under the garb of supernumerary post.
No, don't come to that first. First, you deal with the other main contention. That's the second part. First, deal with the main contention. Is there justification in cancelling the entire
result? Yes, I'm not. On that, I'm showing lordship.
Please concentrate on that before you go to the second point.
No, but I will show this to show that this is really vitiated the entire process. That's why the separation is not possible, because the state government wanted to protect the job of the illegal appointees. Therefore, state government's machination was to ensure that illegal appointment should stay. Now, to support that, I just kindly take the trouble to paragraph 6 at 1171. This is the statement by the School Service Commission before the High Court. It is proposed, it is humbly proposed that apart from giving recommendations and appointment to the genuine candidates, as observed by this Honorable Court in other similar matters, supernumerary posts be also created to accommodate those, if any, whose appointments have been found illegal. Such proposal will result in no loss of jobs or to enable such appointees to have means of livelihood. However, in the event of such proposal being accepted, appropriate directions be given.
This is what? This is a reply?
No. This is an application filed by School Service Commission seeking permission to appoint those persons under the supernumerary category only to protect the illegal appointees. Number one. Number two, when the matter was going on before the division bench gave 4 chances to the School Service Commission to file affidavit. I will show the affidavits. And so far, my lord, the keeping of mirror copies, there is an affidavit by the School Service Commission before the Supreme Court that the decision was taken by Corota. Decision was taken to destroy the original OMRs, keeping the mirror copies. And now ultimately they say we did not keep mirror copies, giving a...
Go one by one. We have understood your first argument that they wanted to even uphold appointment of illegal appointees by creating supernumerary posts. That point we have understood.
Yes. Second
For
point.
your cases, they wanted to favor the illegal appointments, and therefore their stand should not be accepted. That is possible to segregate illegal from genuine appointment.
In support thereof, my lord, I also will not cite that when the division bench asked the SSC that you give me the exact number who, according to you, are legally appointed. The SSC got 4 chances. They filed 4 affidavits. I will just refer to your lordship 2 affidavits where SSC says we are not sure. Kindly turn to at page 3154.
Which volume is that?
Same volume 5B. This is the latest affidavit by School Service Commission before the Honorable Division Bench. Here SSC says for class 9-10 they have classified like this: number identified so far. There is no definite number, and this is the situation in all the 4 categories: 9-10, 11-12, Group C, Group D. In all cases, they are saying that this is not exhaustive. They cannot definitely say. And in this chart also, my lord will be pleased to note that the appointments given out of panel, even persons who did not appear, they have been given appointment. Those data are not there.
Even those who did not appear have been given appointment.
Yes, minister's daughter. That's why he was directed to refund the money. On the last occasion, he appeared seeking my lord's kind leave to get the money back. How many of such cases are there? The School Service Commission could not yet identify. Therefore, this segregation is not possible. That is clearly discussed by the Honorable Division Bench. I will just refer to the 11th paragraph of the affidavit. Now, kindly turn to again the 4th affidavit of SSC, page 3249.
Yes.
Kindly turn to paragraph 5. May I read for my lord's consideration? With regard to the issue of rank jumping for class 9-10, it was stated in the report in the form of an affidavit that out of the 183 candidates, 122 candidates have been removed and 16 were still remaining. However, it is pertinent to further mention that out of the 61 remaining candidates, 40 candidates were neither in the panel nor in the waiting list. That is, they had not participated in the personality test. It may also
What is this remaining 61?
Hello?
The remaining 61 is what?
Who did not even participate.
So 61. 83 candidates to be.
Okay.
Then next.
Out of 183 candidates,
122 they have removed pursuant to direction of the court. 61 they did not, and they did not participate in the selection procedure. Then again, paragraph 6. With regard to the issue of rank jumping for class 11 and 12, it was stated in the report in the form of an affidavit that in cases of 39 candidates, no action has been taken and all 39 are still remaining. However, it is pertinent to further mention that out of the 39 remaining candidates, 18 candidates were neither in the panel nor in the waiting list. There were the persons who were appointed who did not participate. And that number is also not definite. Only these numbers, when you pointed out, to that they give this affidavit.
So 39 is a figure. How do we arrive at 39 figure?
Look, we had pointed out that we come to know these people have been appointed. Then only they say. They don't of their own. Therefore, the court directed you on your own find out. SST did not find on its own. And paragraph 7 is with regard to the OMR sheet. That was interesting. With regard to the OMR sheets for class 11, 12, it was stated in the report in the form of an affidavit affirmed on such and such that out of 907 candidates having OMR issue, 77 were recommended. However, in addition to that said 771, there was one more candidate which the commission inadvertently did not mention in the said report in the form of an affidavit, namely one Rudra Bhattacharya, who was recommended pursuant to direction dated such and such. Subsequently, it transpired that the said Rudra Prasad was one of the 907 candidates for class 11-12, having OMR marks in mismatch, and his name appears in the list of 907 candidates at serial number 854. His marks as per evaluation of scan image of OMR is 23, while his marks in the server of the commission are 53. But that's why the division bench repeatedly asked them and filed affidavit they could not file, giving a particular number. Then paragraph 8 is more important. It may be noted that pursuant to the order dated 2nd December, passed in WPNR so and so, the commission issued letters to the concerned district inspector of schools for stopping the salary of group C so and so. Subsequently, by an order dated 15th February, the Honorable Court was pleased to direct the concerned district inspector of schools not to pay any salary to the concerned candidates any further. By a similar order, the commission was directed to issue letters to the concerned district inspector of schools for stopping the salary of group D candidates who were appointed after the expiry of the panel, and by a subsequent order, directed the concerned DI not to pay any salary to concerned candidates any further. Then 9. It has been stated with regard to the candidates called by the 8th phase counseling on 3rd August 2020. All candidates were called strictly on the basis of merit, though after expiry of the panel. How could the people be called for counseling after expiry of the panel? At the same 8th place counseling carried on 3rd of August 2020, 184 candidates were called out, of which 127 were present. It may be noted that the panel had expired on 19 December 2019. 2 more candidates, one Salma Sultana and one Ritika, was also recommended. Therefore, these are the instances galore, which shows how there has been an institutional corruption. This is not slip of 1 or 2 individual officers. And that's why the Honorable Division Bench kindly considered. Supreme Court, I can't scan images. And the affidavit before the Supreme Court was that we have to keep the scanned images. They did not. Kindly turn to the affidavit by the SSC before the Supreme Court at page 2901. This is at para 2901, para Roman 7, at page 2901, sorry. It is stated that the chairman of the commission in his executive capacity, after the expiry of 1 year in absence of rules, issued executive instructions directing that the answer scripts, OMR and other papers related to the disposed and destroyed at the period of preservation of the same had already expired. The same was to be destroyed after scanning in digital form and creating mirror image. On the first day, the Honorable Court asked them, why did you not keep the mirror image? That was their own decision they violated. These violations were done only to ensure that ultimately nobody can identify how many persons have been appointed illegally. In spite of such, when some RTI applications were made in 2024, they have supplied the copy of the OMRs. That on the other day, the Honorable Court also pointed out at page 1257. These are the nature of illegalities they have committed. This is a letter from Assistant Secretary at page 1257 dated 18th of January 2024. With reference to your petition dated such and such for the classes 9, 10 and the RTI Act as per data stored in commission's data. Now when the judgment could be made. It is so how the division bench had dealt with that.
Which page is the OMR? We were shown the sample OMR. One of the OMRs. Which page is that?
1131. 1131. 1131. The sample of OMRs.
Yes, please. There's the OMR sheet.
Yes.
All blank.
All blank.
Wait.
All.
So 314
That's a group DA.
Are similar that easily identifiable with the candidate. No one else come and say this is not mine. And the Honorable Division Bench gave them opportunity. Come, inspect and tell. None had inspected. The so-called argument of tainted, untainted was never advanced before the Division Bench. Now kindly take the trouble, Milord, to come to the Division Bench, how the Division Bench dealt with this issue.
Division bench. Page number 2. Not of the volume of the copy.
This is from the judgment under appeal, para 312. Options available.
Yes.
Page 247. Got it.
Volume 3.
Volume 3.
The second option was explore the possibility of segregating the valid appointments from illegal ones. Specifically, this was taken up and dealt with. So far at page para 314, so far as the second option is concerned, few authorities, but I am not troubling my lord with these authorities which are well known. Then kindly come to relevant paragraph 321. In respect of 4 categories of the selection process involved, written examination has been held. Written examination was in the form of OMR sheets. Original OMR sheets have been destroyed by SSC. Mirror image of the destroyed OMR sheets was required to have been preserved by the SSC. CBI had seized the server of SSC and did not find mirror image of such OMR sheets in the server of SSC. Then I am just skipping over the unnecessary details. The next page, it is unclear whether, it's better. SSC is an authority within the meaning of Article 12 and have been enjoined with the task of undertaking the selection process. Last report of CBI has stated that SSC appointed Mrs. NISA for the purpose of scanning and evaluation of the OMR sheets. NISA had engaged another organization, namely Data Scantech, to do so. It is unclear as to whether the new agency had merely scanned the OMR sheets or was instrumental in evaluating same also or not. Chairman of SSC, in response to a query of the court, has stated that he was not aware of the engagement of data scan tech in the selection process, and that in fact he became aware of such name only from the court for the first time. No material has been disclosed as to who authorized NISA to engage data scan tech, or such instrumentality was lawfully engaged by SSC. Significantly, it is the claim of SSC that scanning of OMR sheets had taken place at its office. If that be so, then SSC had knowingly allowed another organization to scan the OMR sheets, namely Data Scan Tech, who was not authorized at all. This raises serious questions as to the integrity, sanctity, and validity of the entire selection process, and giving to the root of the selection process. The evaluator of the selection process had been selected through a process which at best shrouded in mystery, if not downright illegal. Then the conduct of such evaluator is such that it affects the validity of the process of evaluation itself. Significantly, NISA had been appointed without an open tender. SSC has selected NISA ostensibly on the ground of it being the lowest tenderer from amongst the chosen few who were asked to participate. The parameters, qualifications required to participate remains undisclosed despite requests being made in court to SSC. No explanation has been provided by SSC in course of the hearing as to how and why such a course of action had been undertaken in identifying the instrumentality who was to scan and evaluate OMR sheets. Documents that have been made available on record does not suggest that competency, efficiency, and whether NISA has requisite expertise to undertake such exercise was not considered by SSC at all. Letter of appointment of NISA contains only 2 lines, which requires NISA to scan and evaluate OMR. No other terms and conditions of the appointment have been specified. The appointment letter has been received by the one employee of NISA from the office of SSC. Then, next paragraph 326. The entire selection process is shrouded in such mystery and in such layers that it is difficult to fathom the quantum of illegalities performed. That illegalities had vitiated the selection process of NISA stands established. We have discussed the illegalities so far discovered vitiating the selection process in course of our discussions, and we'll tabulate the same hereafter.
325
The plausible inference from the materials made available on record and the conduct of the relevant parties is that the entire machinery was devised for the purpose of effectuating a scam, which will be hard to discover and even if discovered, difficult to prove. But for a passing reference, after CBI took up investigation, upon raid to the minister's house, 50 crores cash was recovered, apart from gold and other property. 50 crore cash. These are all out of case. As noted above, in the course of hearing all these matters, SST State Board have perseveringly non-cooperated, so that even the possibility of trying to separate the grains from the chaff would be rendered neglected.
So 324.
And now, finally come to the next paragraph 329. In the facts of the present case, blank OMR sheets have been submitted and such candidates have been shown to have scored sufficiently higher number so as to be recommended for appointment and ultimately given an appointment. The exact nature of candidates fraudulently given the appointments cannot be identified. More so, in view of the attitude of non-cooperation exhibited by SSC, there are other manipulations, illegalities in the selection process which have come to light. Again, exact number of persons who have benefited out of such manipulations and illegalities in the selection process cannot be identified in its entirety. Some have been identified. Identification of some of is such that in respect of Group D appointments, 48% has been found to be obtained by manipulation. The percentage of manipulated appointed persons across the other 3 categories are on a reduced scale compared to Group D, but nonetheless sufficiently significant to question the validity of the entire selection process. Then, without the Honorable Court summarized the illegalities at page 335, I'm not reading to tax your lordship patience. The basic thing is therefore that Honorable Court having made all effort
The report is there,
It is
Yes.
judgment.
it is referred to in the judgment.
but it's not filed.
Not filed?
In this
Not
proceeding,
filed before us.
in this proceeding, not.
But it is recorded in.
But this has been recorded thoroughly in the judgment.
Because if you come to page 269, the last illegality that has been noted.
Yes.
Recruitment
Is
rules
illegal.
governing the 4 categories have not been adhered to either in letter or spirit.
Yes.
These illegalities have been established by Justice Bar Committee report.
Yes.
So there's another issue which has not been touched upon by anybody, whether the recruitment rules have been flouted.
I give a little background. But initially, the Division Bench of High Court appointed Justice Bag to find out. So for the Group C, Group D, since the complaint was that the Board of Secondary Education and School Service Commission, they were filing contradictory affidavit to each other. Justice Bag went into the matter in detail, recommended that those officers should be departmentally proceeded with and criminal case should start. Then only CBI investigation was initiated.
That report was not made public, is it?
Yes, yes, yes. It was.
Why is it not?
It was kept with
The report was read out in open court, and another division bench of Justice Talukdar, in its judgment, recorded in detail what are the report of the Justice Bakri. That is part of the compilation.
That order is there.
Volume 3.
Volume 3.
Page
466.
Page 466.
Kindly turn to page 466.
Volume 3.
Yes. To that page 465 of volume 3. May I just read out?
Yes.
It would be paragraph 11. It would be relevant at this juncture to mention that the Bar Committee was constituted by the Honorable Division Bench. Before the respective arguments of the parties are considered, it would be also relevant at this juncture to place the following important excerpts from the final inquiry report of Bar Committee connected to appointments in Group D post in government so and so. The excerpts read as follows: backdrop of the inquiry. The West Bengal Central Service Commission published advertisement for selection of candidates to fill up Group D post in government-sponsored schools, except Hill region, by conducting 3rd regional level selection test for recruitment of non-teaching staff. The written examination was conducted on February 19. 1,13,000 odd candidates participated in the written examination, which was conducted by providing OMR sheets to the candidates in different centers of
13 lakh.
Yes.
Not 1,13,000. 1,13,000.
11 lakhs. The number is huge.
So it's 11 lakh.
A writ petition was filed in the Honorable High Court at Calcutta in connection with publication of the panel in the website, as the candidate who participated in the selection process could only see his own result in the panel by inserting his own number and date of birth. But he was not in a position to know his own rank vis-a-vis rank of other candidates from the panel. The publication of panel in the website of the Central Commission was not in accordance with the provisions of Rule 14, bracket 15 of the West Bengal's selection rules. His Lordship, the Honorable Justice Moushumi Bhattacharya, disposed of the said petition by directing the Central Commission to publish the entire panel in terms of rules within a period of 1 week from the date of the order. Since the Central Commission did not comply with the direction of the Honorable High Court, a contempt application was moved, and ultimately the Central Commission published the entire panel in the website on June 20th. After about 1 month from expiry of the panel, the chairman of the Central Commission issued a notification declaring expiry of the validity of the panel for selection of Group D post with effect from May 4, 2019. With the above factual matrix, 4 unsuccessful candidates, including so-and-so, filed writ petition. praying inter alia for direction upon the chairman of the commission and the chairpersons of 5 regional service commissions to fill up the residual 108 vacancies of Group D by counseling. I'm just skipping over, then just down below, 3 lines below. By supplementary filing affidavit petitions brought to the notice of the High Court, names of 523 candidates who got appointment in Group D post by the President of West Bengal Board on the basis of recommendations made by the Chairperson Regional Commission after expiry of the panel on May 4, 2019. In course of hearing of the said 8 petition, the Central Commission and all the regional commissions took the stand that the chairpersons of the commission did not make any recommendation, kindly notice this, for appointment in Group D post in schools after expiry of the panel. On the other hand, the board filed an affidavit disclosing the original recommendation letters under the signature of the chairpersons of the regional commission after the expiry of the panel on May 4, 2019, on the basis of which appointment letters were issued by the president of the board to all those candidates after expiry of the panel. The appointments of more than 500 candidates in Group D post on the basis of recommendation of the expiry of the panel may so and so, coupled with the contradictory stand taken by the board and the Central Commission, as well as the Regional Commission, led the Honorable Court to observe in the order that corruption writ large in the whole process of the public employment and directed CBI to conduct an inquiry into the extreme illegality in making recommendation and appointment to the undeserving candidates in Group D post. The order dated so and so passed by the Honorable Court was challenged before the division bench by performing force. Number, the single bench directed the CBI in order to secure appointments of undeserving candidates in Group D post was not found favor of the honorable judges of the division bench in High Court. On December 6, the Justice so-and-so disposed of all the appeals by taking the decision to conduct an inquiry to reveal the truth in connection with illegal and or irregular appointments made in Group D post by constituting special team to be monitored by a retired judge of the High Court. The honorable judges of the division bench modified the direction given by a single judge to secure equal opportunity to successful and deserving candidates for appointment in Group D post by revealing the truth and by fixing up the responsibility for the misdeeds of giving a recommendation and appointment in Group D post in an illegal manner. Since the inquiry committee could not submit the report, the completion of inquiry within time, these are procedural aspects, I am not telling my lord. Then kindly turn to
page 40.
Paragraph page.
Page 470.
Kindly come to paragraph paragraph 6.1.
Page 475. 471 চলে আসো 470.
Paragraph 6.7 of the
page
that been
page 470.
Maybe page 471.
Yes.
Result of illegal procedure adopted by the Central Commission, the Regional Commission, the Board. In view of the illegal procedure adopted by the Central Commission, the Regional Commission, and the Board, 609 unsuccessful candidates got false recommendation letters from the Office of the Central Commission, which were prepared by using fictitious memo of the Regional Commission. These are all findings of Justice Bar. Fixing scanned signatures of the chairpersons of the Regional Commission by keeping them in the dark after the expiry of the panel on May 4, 2019. The said 609 unsuccessful candidates who obtained false recommendations from the Central Commission also received appointment letters based on the false recommendation from the new building of the Central Commission situated near Anandalo Hospital. We have annexed the names of 609 candidates, their father's name, district, region, name, school, so and so, by the president of the board by preparing a format which is annexed to the report and marked with annexure. We have made analysis of the information collected from the Central Commission and the board and found that names of 318 candidates who got false recommendation even when their names did not appear either in the panel or in the waiting list. The names of 318 candidates, their father's name, full address, so and so, and date of recommendation letter and date of appointment issued by the board, who got false recommendation appointment, was even when their names did not appear either in the panel or in the waiting list next to them. But this massive corruption practiced by state authorities. Then what I'm just skipping over.
483.
Kindly come to paragraph
4.7. 4.7.
Kindly come to fixing of responsibility. এখান থেকে দেখা তো স্যার একটু এই পেজ ফোরে ওটা পেজ ফোরে স্যার এই সেই সময় না দিকে গেলাম 483 the group. Now kindly turn to me, Lord, page 483.
Yes.
4.7.
4.7. Result of illegal procedure adopted by the Central Commission, the Regional Commission and the Board in view of the illegal procedure adopted by the Central Commission, Regional Commission and the Board. 381 unsuccessful candidates got recommendations from Group C post after expiry of the panel, though those candidates did not qualify for being considered.
This is a set figure. This is a fixed figure.
No, these are all illustrative. Initiation. But these are all, as I say, is illustrative. Nobody can, even the School Service Commission, till the last date of hearing, come up and identify that these are the figures which we stick by. I placed before Lordship, they said identified so far. There are other areas manipulation also, giving deliberately false marks in violation of statutory provision. And appointments given in excess of vacancies. All these things are there. Ultimately, when the CBI conducted in, they have secured some OMR sheets, and the entire argument before the High Court was that you cannot look into those OMR sheets. None has argued, with the best of respect and stand to be corrected, that we are genuinely candidate. We have nothing to do with this. Please segregate us. I don't find from the entire judgment, which was so elaborately written by the Honorable Judge, taking all pains. Therefore, there was no scope for any segregation. And now, my Lord, I will just invite my Lord's attention. I was shocked how this selection was made to NISA. This is also well planned. The kindly turn to page 1264, volume 5B.
Yes.
Now page 1262.
Yes.
What you will kindly note, two important state organizations like Saraswati Press and Shilpo Bhatta, government organization. They were initially knocked out. On what ground? That they have only given the quotation for 1 and 2. And the rest are, you will kindly see the rate quoted. So for the A, B, C is concerned, only difference 9,000, 8,500, 8,000. All 500 rupees difference. And this was handed over on the very same day when this was opened. The issue for tender was designing and printing OMR, scanning and preparation of results, consolidated transporting costs, and so. Therefore, basic work was designing and printing and scanning and preparation of results. Then kindly come to the next page. Then kindly sees at page 1264, from the chairman to the vice president of NISA, date is 1st of December 2016. Subject is scanning of AMR and processing of result, both secondary, higher secondary examination. What court has been issued? Dated 24th of October 2016. With reference to above, you are requested to start scanning of AMR sheets of both secondary, higher secondary, and process result of the same in due process. This is received at the very same office on the very same date by Ajoy Shah, some Shah, who is representative of NISA. How could he be there on the date when this notice was issued? And the address of NISA is Noida. How could the gentleman know that this day will open? This is all pre-planned. And then next page. This is 29th of March 2017. Subject of scanning of AMR and processing of result in connection with third SLST. What are the work assigned? Scanning and processing of results, refund of AMR sheet after completion of the process, handing over of scanned images of AMR record of results, the other information soft copy mode with the clarification. Therefore, these AMR copies, scanned images were handed over. Where is that gone? And then 1267. 7 September 2017. Some additional work is assigned to them without having invited them to participate in any tender process. And that again on 7th of September, the Honor Shah was in office and received this. And the nature of job awarded was in understand for finalization of typing schedule. The work includes arrangement of venue, conduct of type test, evaluation of paper, handing over result. Therefore, all these things taken in a basket, it would be apparent without any out of doubt that this was done with now
list of persons appointed after election is the vacancy and then
now kindly take the trouble to turn to paragraph 271 of the judgment. This is very important. At page 228. Rather, I would be prompted and tempted to read from paragraph 262.
Page number?
Page 227, 219 of the input judgment. Paragraph 269. The SSC board and state government have consistently stonewalled any queries with regard to the selection process and have not come clean with regard to the manipulation and illegalities involved. Conduct of three authorities during the course of hearing can be classified as anything other than being cooperative. The Secretary of SSC has submitted a statistical report with regard to the illegalities in the appointment in the respect to the four categories by a signed report dated March 6, 2024, to which we have alluded to herein. In course of hearing, SSC in response to queries of the court has submitted details of the recommendations made by SSC in respect to the 4 categories, and number of appointment letters issued by the board in respect to the 4 categories. Significantly, SSC had recommended 11,425 candidates for appointment post of assistant teachers for class 10, whereas board succeeded in generating 12,946 appointment letters, thereby issuing 1,539 excess appointment letters. Now, who is going to identify them? Then the board has entitled to similarly in respect to assistant teachers for class 11 and 12. The board had 5,756 appointment letters as against recommendation of 557 candidates by SSC, thereby issuing 199 excess appointment letters than entitled to. In respect of Group D, board has issued 4,550 appointment letters against a recommendation of 381, thereby generating 669 excess appointment. In respect of Group C, board has generated so and so, thereby generating 416 excess appointment. Justification that has been sought to be preferred by board is that all appointment letters were on the basis of the recommendation of SSC. SSC has contradicted such justification of board by claiming that no such recommendation letters were issued. Board has no authority to issue appointment letters unless such candidates is recommended by SSC. In 4 categories involved, there have been appointments far in excess of the recommendations. There have been manipulations, illegalities in the recommendation also. SSC at no stage of hearing claimed that it was able to check all the records and be definite so as to the number of illegalities in recommendations made, but had limited itself to those figures as stated in the paragraphs above. In fact, reports in the form of affidavit filed by SSC from time to time had always stated that they discovered the illegalities as were brought to their notice by the litigants or on order of court. The SSC had proceeded to withdraw cancel recommendations in favor of candidates participating in the 4 categories on the basis that there were manipulations in obtaining recommendation. SSC had accepted the data found in the hard disk seized from ex-employee NISA, Pankaj Bansal by CBI. Then kindly turn to paragraph 288.
Two
288. None of the Article 12.
Yes.
None of the Article 12 authorities had ever disputed the genuineness, veracity, authenticity, and legality of the data contained in 3 hard disks seized by CBI from Mr. Pankaj Bansal at any material point of time. SSC had accepted such data acted upon, found manipulations, illegalities, machines, proceeded on basis of such findings and withdrew cancelled recommendations of various candidates. It had utilized such data to arrive at a finding that OMR sheets had been manipulated, and the marks obtained by candidates stored in the server were considerably higher than the marks which such candidates could have received. On a thorough and proper evaluation of the OMR sheets of such individual candidates found in the hard disk seized by CBI. The third hard disk seized by CBI had been produced in court. CBI had granted inspection of documents downloaded from such hard disk to persons seeking such inspection pursuant to orders of this bench. None of the persons taking inspection have contended that the OMR sheets are not theirs. The OMR sheet bear a unique barcode, and I've already spoken about this. Therefore, this is the wholesome figure of the illegalities committed. And I don't have to do that.
But their contention is OMR sheets under the rules have to be only maintained for an year.
But the decision was they will destroy it, keeping mirage copy. That is the decision of the SSC. That affidavit I have placed with Dr. Malkota.
So the mirror copy was there, But there is discrepancy in the mirror copy.
Mirror copy was not there.
They,
Mirror copy was also not kept. That is the whole game.
no, they gave it to somebody else to do it. They kept it on their server or their computer rather than the system.
SSC storage, it was not there at their own admission. And the CBI also did not find the mirror copies from the SSC server.
Decision was taken somewhere.
But the specific decision, as I have referred to, Lordship, kindly turn to page 2901 of volume 5. It was the decision. I just read out once again loudly. It is stated that the chairman of the commission, in his executive capacity after the expiry of 1 year in absence of rules, issued executive instructions by letter dated 22nd July 19, directing that the answer scripts, OMRs, and other papers related to the disposal and destroyed as the period of preservation of the same had already expired. The same was to be destroyed after scanning in digital form and creating mirror image. That's the norm. The physical image is destroyed to get rid of the space. But there is no lack of space in space.
2023 records.
And this was the affidavit filed before the Supreme Court by affidavit on 16th of March 2023. Now that I think the law is well settled, I really would like to bring one judgment to your Lordship notice, where the Supreme Court has said if there's any out of doubt, then the entire thing should be cancelled. And the Honorable Court directed to do it afresh. What's the harm in it?
Not fresh means everybody has to study again. So, just exercise.
Some trouble has to be taken.
Among the candidates.
But this is only for the selection amongst the candidates who had appeared, not from the outsiders.
So it's only for those candidates who had appeared.
Yes.
Not for any outsider.
Not outsiders. Like it will be pushed back to 2016 situation. Who are the candidates? They will appear, and the age bar will be unknown.
No, if that examination is being held today, there is no question of age bar.
That's not. Even if somebody has expressed their doubt in mind that age bar would come in, it will not come in. Now that
it's not meant, it will not be a fresh advertisement.
No.
It's only confined to those
only confined to the participants who had participated. Now that I was not tempted to cite this judgment, Tanvi Sarwal versus CBSE, this is 2015, volume 6 Supreme Court cases.
573.
2015?
Volume 6.
Page number?
573. But the relevant paragraph, I just cite. Well, I'm reading from paragraph 20, as would be available from the status report.
Yes.
As would be available from the status report, out of 123 solved answers on particular code and retrieved from the mobile set of one of the persons arrested. 102 answers were found correct in a comparison with the answer key provided by CL. As referred to here, above 358 mobile numbers had been pressed into service and at least 300 vests fitted with electronic devices have been used. Having regard to the uncompromising essentiality of a blemishless process of examination involving public participation, we have no alternative but to hold that the examination involved suffers from an infraction of its expected requirement of authenticity and credence. We are conscious of the fact that every examination being conducted by a human agency is likely to suffer from some shortcomings, but deliberate inroads into its framework of magnitude and the nature as exhibited in the present case, demonstrate a deep-seated and pervasive impact, which ought not to be disregarded or glossed over, lest it may amount to travesty of a proclaimed mechanism to impartially judge the comparative merit of the candidates partaking therein. If such an examination is saved, merit would be a causality generating a sense of
OMR sheets are available. Scan sheets are available. That can be reassessed.
one way of looking at it. So, but at the same time, investigations carried out when the allotment of academic marks and to give benefit to the persons who have paid money, the alteration of their personal test marks. These are all serious allegations are there.
No, there are two ways. Is there any finding recorded that the OMR sheets there are two OMR sheets we have? No, scanned copies two are available. There's several or two?
Page 11. Scanned copies available, according to us, not in the website of the SSC.
That's page 1131, what you showed us.
1131, they supplied, they now say this is from the CBI report. That's the explanation given for the court.
No. That's something separate. There are two OMR scanned copies of OMR sheets. Both of them can be compared to know whether there is any violation.
No, there is no two copy.
One copy given by the CBI. Marking it can do what he wants.
Only one copy which was seized by the CBI, nothing else.
No, there are two copies available. There's only one. No, Pankaj Bansal and the other person also had.
Oh, Pankaj, yes, same. Same.
No, there are two. I thought there are two sets of OMRs.
Two sets up there, from two agencies, and the same.
Pankaj Bansal has one. Where is the other one? NISA said it.
Data scan tag.
Data.
Data scanner, the chair.
Therefore, whatever CBI has seized, that is there.
Both CBI have examined them and have segregated.
No, there are two sets available. Are the two sets matching or not matching? The two sets as per them were matching.
That's matching.
On the authenticity of that itself, because the marks which have been allotted are not in seriatim with the OMR sheets. But they were marks to be allotted on account of academic score also.
The rules, I will place the rules. rules prescribes, first of all, academic qualification, then OMR.
Please allow us.
স্যার স্যার আপনি বলুন স্যার স্যার আপনি বলুন রুলসটা পড়ুন স্যার
Pardon?
স্যার রুলস পড়ুন স্যার
As per the rules, of the merit, is the academic marks, is the OMR sheet, and finally, the lordship's the verification. So when all these three are added, the percentage which is given to my academic record, your lordships, I'll just read the rule, is about 40%. So if I know that I have scored 98% in my qualifying exam, your lordships, even if I do badly in my OMR, I would still have higher marks. I'll come to all that, your lordships. I'll show to your lordships that aspect.
No, no.
958. That is 958.
May I complete?
Yes, yes.
Now, Lordship now kindly takes up the rules. What we are trying to and confused. Volume 5B. These are statutory rules.
Yes.
I'm just pressing the relevant portion. The Central Commission shall arrange written examinations. The Commission shall determine the method of written examination, contents of papers, so and so. Then, after the evaluation of OMR sheets of the written examination, the Central will prepare and publish in their website all details of the candidates to be called for personality test category-wise on the basis.
Now, first the OMR sheet result is declared.
Yes.
The OMR sheet result is declared.
On the basis personality test.
No. On the basis of the scanning done, after evaluation of the OMR sheet or sheet and the written examination, shall prepare and publish on the website the details of candidates who have been called for personality test.
Right.
Now, therefore, the results of the OMR sheet were already declared then.
No, your lordship, they were not declared, but that was one of the orders that
Is it?
the court made, and consistently they did not.
This was not done.
Not done. That triggered the litigations.
This was not done.
No. Only after the Honorable High Court intervened, directed, then some marks were disclosed.
In the year 2000.
No, this was not done. This was not followed.
No, your lordship.
In the year 2022.
That's why the direction was given.
I'm asking him.
Yeah.
Now kindly come to the relevant rule.
It was done before the interview or after the interview?
Before the interview.
No, publication was done before the interview or after the interview?
Publication was never done. When it was challenged before the High Court, then on direction of the High Court, it was done after everything was complete appointment.
After the completion of appointment.
And after giving appointment.
In 22.
It was done in 2022.
June 2022.
Now kindly come to the relevant definition of interview list.
Petition, was it disposed of within a year or after the year?
The petition.
Yes.
The petition was still pending, many issues.
You read out. Direction was given by the High Court to publish the result, OMR result. When was that petition filed?
In 2021.
And when was the result declared?
2022.
22.
June 2022.
22.
How can that be? You said it's after the declaration of result that the marks obtained in the OMR sheet were declared. Correct? You just now said that.
Probably I'm not able to communicate. But the OMR sheets were never disclosed. Marks were
correct. You said the marks obtained in the OMR sheet contrary to clause number 6 were declared pursuant to direction given in a writ petition after the final results had been declared. Correct? I asked you, when was that writ petition filed? You said 2021. When were the results declared? You said 2022.
Well, dates are confusing.
Results declared in 2018.
But the
results were declared in 2018.
2018.
When was the writ petition filed?
2021. 2021 it was filed, that's why they get 2018. When you come to know, then you challenge. Now that
No, the first writ petition for declaration of the results, for the declaration of the OMR results was filed in 2021.
Now it was filed seeking the details of that, the merit standing, what marks were to obtain as per the rules. That was the writ petition. Now kindly turn to definition clause 2E. Interview list means a list of candidates to be called for Rule 2, Sub-Rule E, page 1998.
Yes.
Interview list means a list of candidates to be called for personality test, category wise on the basis of merit, that is marks of written test, academic and professional qualifications. Therefore, the academic marks and professional qualification is also very important for calling for interview. Then panel, I am not troubling my lot with the panel. So kindly come to rule 12.
Page number?
The page is 2001.
Yes.
Selection of candidates and preparation of panel. The Central Commission shall arrange for proper custody of all online applications which may be received by its against the vacancies. The Central Commission, after receiving, I'm not troubling with that. Then 4, the Central Commission shall determine the method of written examination, contents of papers, duration of examination, time and venue of examination, and other matters. Here, the Central Commission delegated everything to NISA. Statutory obligation was the Central Commission should do it, they did not do it.
Yes, but oh, this may not be violated. This may not be really violated. This is only the method they have to determine. This may not be violated.
Yes, well, I'm just making my submission also consider this. Then, after the evaluation of OMR sheet or answer sheet of the written examination, the Central Commission shall prepare and publish in their website with all details of the candidates to be called for personality test, category-wise on the basis of merit in the ratio of 1:1.4. This was not done, and violation of this ultimately triggered the writ petitions.
What published?
When was this writ petition filed?
2008.
This writ petition was filed in 2021.
Not in 18.
No, not. They didn't know this.
You didn't know it because the merit list was never published.
Never published.
So there were letters which were sent.
But when we find that somebody got appointment, we wanted to inquire, how could he get appointment? Because I know him better than that. I was never worse than him. Then ultimately these petitions came, and kindly come to page 2008.
They were published.
What was published, I'm showing your lordship. 2008. Kindly turn to 2008.
Yes.
Here, lordship will not find what are the merit position, what are the marks obtained, nothing, all vague.
The wait listed was published.
waitlisted, merit everything without giving the details of it. As per the rules.
When was this published?
This was published in 2018.
No, but the merit list was not published, the wait list was published.
This is not the merit list.
So this W1 means what?
Waiting list 1.
So what? No, the ones who had been appointed, their list was never published. No, was the list of the candidates who were selected published?
Yes, it was published 2018.
Where is that? It's where is that?
Without giving the detailed marks. Which page? That is annexed Karachi.
Not being annexed. Not annexed.
No, it is not a part of the Then again,
where is that list of the students or the candidates who were selected published? When was that published and where is that list?
That list commission can disclose, but we don't have copy.
You don't have copy.
August 2018, a list of selected candidates was published.
August 2018.
August 2018.
Preliminary result was 10th of September 2000.
And appointments were made thereafter.
Yes.
Now the page 2020, there is a list. This was published pursuant to order of the court. So it says compliance of the order of WPS so and so of plus 9 and 10.
Here the marks were disclosed.
This is the first time marks are disclosed after the order. And this was disclosed in 2022.
Okay.
This is volume 5B.
Yes, please.
Now kindly come to the again the rules. That is very important. So we got the book.
2001.
Without marks.
Without detailed marks. Without detailing marks, we have published, marks was published after the court order. Now kindly come to the rule 12 once again. Rule 12, sub rule 6.
You have read that?
No, I'm not sub rule 6, because I did not read.
Rule 12, sub rule 6 you read.
Yes. Therefore, because the requirement was to publish with all details of the candidates. This having not been done, then these petitions were ultimately coming to court for seeking disclosure.
No, if you read A,
17, 18 publication, they are not showing that.
2000, you know, if you look at sub-rule A, it says Central Commission shall prepare and publish their website a merit list based on panel of candidates, category-wise of the merits list equal to the number of vacancies and region-wise list on the basis of option exercised by the candidate.
This is final list.
And prepare and publish on the website category-wise list, waiting list on the page. It doesn't talk about publication of marks, but what is 6 does, and that list is to be published before the academic or professional qualifications are finally.
This is the merit panel.
There are two stages, different stages. 6 is prior to interview, 8 is after interview, and all details are the requirement of law. And you remember that chapter is over, it was published at the order of the court, and then this.
This list which was published as per this 12.6, none of you are showing us. This 12.6 merit publication according to Mr.
It was not published. It was not.
Which page is it?
No. What was published was the merit list after the after academic evaluation.
Where is it? Which page is it?
No, that's not the point. Let's be very clear. Merit list was not published. The list in terms of clause 6, subgroup 6 was not published, giving the details of marks of each and every student. No, that did not happen. No, read rule 6 is very clear. No. 12.6 is very clear. The evaluation of OMR sheets or answer sheets in the written examination. After evaluation of the OMR sheets or answer sheets in the written examination, the Central Commission will prepare and publish in their website all details of candidates to be called for personality test, interview list, categorized on the basis of merit, marks, academic, so and so, in the ratio of 1:1.4. No, with
So Jaydeep Gupta, why don't you show us what you published?
Yes.
Which page is the publication that you came out with in terms of Rule 12.6?
you must have please, you must have taken a print out of that. Which page is it? Or is there none? What you are saying is you could go and look at your marks individually. That's not what. Where is that?
Had it been so, there was no question of litigation before the court.
First order would have been.
Yes.
We are asking you which page is that list. Can we have that? Okay.
Therefore, the court not being satisfied that the state government's involvement was very questionable, the directed that CBI should also inquire into the matter. What prompted the state to create so much supernumerary posts has a different meaning. I'm not going to argue on this. They wanted to diffuse the grievances of the people who are standing in the road. We give you appointment. And an application before the court that we are giving appointment to secure that the persons who have been given illegal appointment, specifically mentioned, do not lose their job. Why? State government was here before the constitutional article 14 was stares at our face. Transparency and non-arbitrary is a fundamental principle of our jurisprudence. In that background where I do not take much of your time, my submissions I conclude saying that the entire selection process has been vitiated.
Okay.
There is no investigation and let it done afresh. Deeply obliged.
You want to go?
Only about 3-4
Now,
paragraphs.
just now tell us in brief why the entire selection process is vitiated. It's impossible to segregate and find out the ones candidates who are meritorious with those who are not meritorious. Please come on.
Milord, the High Court, Milord, has given reasons, Milord, why it cannot be
So
segregated.
please do it in your own words. High Court reasons we know.
I can only read those paragraphs, Milord, of the High Court, Milord. Your Lordship may kindly see, Milord.
See one example. Page 59. Volume
Page 59. Yes. Yes.
Again, no marks in this.
No marks.
No marks.
No, there are no marks.
This is for first stage counseling means that is where the academic results will be examined.
No marks is given.
No, marks are not. You are right. Marks are not given.
But the marks are not on the website. So each part, if anybody wants to investigate that,
Always show
But the
there.
marks are not there. The requirement of the rule, my lord, is publication.
Page number 82, 1 to 1.
Not that no marks are given.
1 to 1.
Page 1 to 1. Page 82, my lord.
No mark was given. Even 1 to 1 mark was not given. 1 to 1 mark was candidate, particular candidate.
One communication, my lord, page 82, my lord. Volume 5, bill. Marks, my lord, are conspicuously absent. No marks.
No marks.
So where are the marks?
Where is the marks?
Where are the marks?
Marks are not there. Their condition is marks are not required under the rule, sub rule 6.
But if your lordship may kindly see, my lord, that, my lord, it was an ongoing process, my lord, of, my lord, illegalities being detected, my lord. If your lordship may kindly see a paragraph, my lord, paragraph 242, my lord, of the impugned judgment, my lord. This is the stand of the SAC, my lord. So, my lord, it was, my lord, time and again brought to the notice by way of affidavits, my lord. The first line itself, my lord. In course of hearing, SSC did not discount.
Paragraph or
Paragraph
page number?
242.
Paragraph 242.
Paragraph 242, my lord.
Yes.
But in course of hearing, my lord, the SSC did not discount the fact that possibilities of further illegalities exist. So they are not certain even, my lord, on the date of passing of the order, my lord, as to the number of illegalities, my lord. Then your lordship may kindly see, my lord, page 260, paragraph 265, my lord. The court, my lord, is court, my lord, between, my lord, the state and the board and the SEC. It's a strange stranglehold on the court. Your lordship may kindly see, my lord, page 265. This is, my lord, a state is supposed to be a model employer.
Yes.
Paragraph 265, my lord, beginning inferences from the role of Article 12 authorities. The inferences, my lord, if I may read, my lord.
Yes.
In fact, a paragraph before that, the stand taken by the Chief Secretary. These are very harsh words, my lord, the court was compelled to use, my lord. Paragraph 264, my lord. The obdurate attitude of the Chief Secretary has to yield to his obligation to uphold the rule of law. They were all along, my lord, there are a number of words, my lord, that the learned judges use, my lord, as to how they are trying to play ducks and drakes. I can, my lord, highlight, my lord, in a one-page, my lord, note as to how, my lord, these three authorities, my lord, have tried to mislead the court in three different directions. Your lordship may kindly see the para I, my lord, wished your lordship to read, my lord, para 265. The state government therefore has accepted that there were widespread illegalities in the selection process and that the number of persons who received appointments illegally could not be determined with exactitude. So 242, my lord, has to be read, my lord, with 265. And then, my lord, they go one step further. Now, my lord, you detect the illegalities and you perpetuate them. The next line is very important. They had resolved to create supernumerary posts to accommodate the illegal appointees.
Just one thing we'd like to know. Paragraph 265. As far as the state government and the SSC is concerned, you accept that statement of fact? One minute, please. SSC, because this is on the basis of what has been stated. Be careful that you don't make a wrong statement. Just be careful you don't make a wrong statement, because if it was so stated before the High Court, it's matter of, so must be a matter of record.
Lord, it is there at page 30 in the submission, my lord, para 30, my lord. The submission made by SSC in the High Court.
They just read out that. But just we like to answer after they've completed. We'd like you to answer that.
Lord, para 30. Exactly.
Para 30 of the written submission.
30, my lord, of the impugned lord.
Judgment. Yeah, while dealing with their written submissions.
So this is the, my lord, admission, my lord. They have admitted before the High Court.
Page 106.
Page 106, my lord, para 30, contentions of SSC, my lord. Excellent. Para 30, my lord.
Yes.
Dr. Sutanu Patra, appearing for the School Service Commission, has referred to the 4 affidavits filed in pursuant to the order of this court. Lord, the affidavits, my lord, your lordship can make a note, my lord. They are page 545 to 553. 545 to 553. 554 to 604.
554
to 604. 605 to 701. And my lord, 701 to 756.
Yes.
But he has drawn the attention of the court to the steps and measures that SSC took subsequent to the discovery of illegalities in the selection process. He has contended that SSC took such steps on the basis of the data supplied by CBI. He has pointed out that SSC had no material to disbelieve the data supplied by CBI. Not CBI also, my lord, is in an ever evolving process. They are still in the process. Moreover, SSC has acted pursuant to the orders of the court. Lord, I am not.
No, but this is something different from what is laid
out at 242.
What you read out at 242.
Yes, my lord, what at 242, what I read out, my lord, is, my lord, the conflict between the board, my lord, and
They said that they did not discount the fact that the possibilities of further illegalities exist.
Yes,
Did they say that in any of those 4 affidavits?
Anyway, please, somebody else will point it out. If they...
Your lordship may kindly, my lord, I'll just read, my lord, para, my lord, 271, my lord. And my lord,
4 affidavits to disclose that they have been varying from time to time. It's referred to in the submission.
my lord, when the illegalities were seen, my lord, the numbers are given 271 and then, my lord, page 229. Justification that has been sought proffered by the board is that all appointment letters are on the basis of the recommendation of SSC. But SSC has contradicted such justification of the board.
Which page are you? Which paragraph?
But para 271, my lord, on the next page, para 229.
Oh yes, yes.
Justification that has been sought proffered by the board is that all appointment letters are on the basis of recommendation of SSC. But SSC has contradicted such justification on the board by claiming that no such recommendation letters are issued. So between the SSC and the board, my lord, there is open contradiction.
In any case, you are beyond recommendation.
And my lord,
We have taken that into consideration in the number we have given of the intent.
Para 271 documents the number of excess appointments in each category. After this, you got together and patched it up?
Yes. Not zero. None of the. Your lordship, just imagine, my lord. Your lordship, just imagine, my lord, an OMR sheet, my lord, where nothing is written. Just imagine, my lord. And my lord, it is checked, it is recommended by the SSC, my lord, appointed by the board. Just, my lord, and my lord, your lordship may just see, my lord, what these people are going to impart education to children. Where will, my lord, this country go? No, according to me, my lord, what?
Let's suppose somebody is recommended and he doesn't take the post. Then a second recommendation has to be.
We understand that. You're not right.
That is always.
Derek, you don't have to argue that. We understand that part. You don't have to argue that. But look, you also realize there is wrongdoing. The question only is wrongdoing is of that level that we can't now separate merit from illegally appointed. So that's all.
At 5
different. You are also in this. You are also helpless. In a way, you are helpless.
Mr. Gupta was
and the board.
Mr. Gupta was kind enough to say, my lord, at the first instance, Mr. Gupta was kind enough to say, my lord, that he can't improve post facto. He can't improve. Then
continue, please. It's already good. It's more. We have already crossed about 4:45. Please let it continue.
Duplication is marginal. That's about it. I won't say anything.
Duplication of arguments.
But para 273, I'll just complete. Your lordship will not have been patient enough to okay. Everybody, my lord. But para 273, my lord, after the infighting between the SSC and the board, my lord, as to, my lord, the kettle calling the pot black or vice versa, my lord. But SSC had at no stages of hearing claimed that it was able to check all the records and be definite as to the number of illegalities in recommendations made, but had limited itself only to those figures. So they could never check also, my lord. And my lord, that could reflect, my lord, in one of the affidavits, my lord. I had referred to, my lord, 3-4 affidavits. It is at page 650, my lord.
Of miscellaneous volume 5B.
Of miscellaneous volume 5B, my lord.
This is a paper.
Done?
Paragraph such as paragraph 6.
Paras at page 650. This is the SSC's affidavit, my lord. Hopefully in black and white. May I read, my lord? Para 6, my lord. However, I say that there may be more candidates who were wrongly recommended for appointment by the commission, for which I most humbly pray for some more time to further verify the records of the commission and to produce the list of such candidates.
Date of this affidavit.
No, I'll just give it to them.
This is affidavit.
This is the third affidavit, my lord. Third?
September 22.
September 22.
22nd September. Okay.
22nd
September 2022.
28th September.
This is a third affidavit.
Number identified so far.
Number identified so far.
It's 315.
So, my lord, there is no definite number, my lord, as to the number of illegalities committed. They are all hunting in the dark. No, no, your chart is worthless, my lord.
Sir, page 315 identified so far. Page 315.
Okay, yes.
My lord, there's another chart, my lord, my learned friend here, my lord, prompts me to, my lord, request your lordship to kindly see, my lord, at page 3154, my lord, of the same volume, volume 5B, my lord. Ours is volume 5B, my lord.
3154,
my lord.
Yes.
Simplified so far, because before the division basis. We agreed with 2023 before the.
My lord, where class 9, 10 is mentioned, my lord, it says, my lord, number identified so far.
There is a seats were 2006 when the division.
Well, Mr. Bhattacharya, my lord, has placed that. Now, my lord, if your lordship may kindly see, my lord, the stand, my lord, of the learned advocate also before the High Court, my lord. I should not be reading this, but in fact, if your lordship may kindly see, my lord, para 268, my lord. Your lordship may read it.
Yes.
Lord, para 268, my lord. This course of action has been adopted by the state. Your lordship have that, my lord?
Yes.
In order to prevent discovery of further manipulations, illegalities in the selection process, if possible. And now, very important, my lord. The SSC, the board, and the state government have consistently stonewalled any queries with regard to the selection process and have not come clean with regard to the manipulations, illegalities involved. The conduct of the three authorities during the course of hearing can be classified as anything other than being cooperative. My lord, there are other words, my lord, used, my lord, for the advocates appearing, my lord. I don't, my lord, want to wish to highlight it, my lord, but just suffice it to say, my lord, that there is a three-pronged attack, my lord, on candidates, my lord, who had good marks, my lord, who could have, my lord, been good teachers. But, my lord, because of this monetary consideration, my lord, today, my lord, I'm given to understand, my lord, that the minister is still in jail about 2 years' time, my lord. 50 crores found, my lord. I don't want to, my lord, put the criminality into it, my lord. But, my lord, the level to this, the level, my lord, to which these three authorities, my lord, have fallen, my lord, to ensure that the education system, my lord, somehow is, my lord, affected, but my pockets are full. And this is, my lord, the basic feature, my lord, in this large, as Mr. Bhattacharya said, my lord, institutional criminal conspiracy, my lord. And, my lord, I would say, my lord, one thing, my lord, if your lordships are, my lord, with us, my lord, then there are, my lord, there is a direction passed, my lord, for return of some monies, my lord, for those people who somehow taught within inverted commas. My, my lord, prayer and request to your lordship would be, my lord, to make this as an example, my lord, and, my lord, fix the three authorities with such cost, my lord, so that this never happens again, my lord. It should be, my lord, I think, my lord, at least 500 crores for each of them. It would be, my lord, if you make a calculation, my lord, I was there, my lord, about 7 to 8, 10 lakh rupees each candidate has paid. Is, my lord, what is in the corridors and the grapevine, my lord, has got, my lord, enough effect.
So, yes, next.
What Mr. Rahim has said, para 329 also achievement. I mean 103, it is the calculation of what Mr. Rahim has arguments. 329 is the conclusion. And that's where they say it cannot be segregated. So that's why cancellation of the entire selection.
Lordships, I'm appearing for the people who are saying that it can be segregated, and I'll just explain to your lordship.
So, appearing for?
The people who are saying that it can be segregated.
No, you should have come on this side.
This is what we say. Should
I'm
come
on
that
this
side.
side because I'm not selected, your lordships. I would.
No, we were very clear. We were very clear, you should have come on that side.
The reason is this, that I am.
So, just wait for your turn, let others conclude.
Yeah, just read this para 329. Yeah, that's what
we have already marked that paragraph.
Great. This is the entire conclusion that why this selection, this cannot be segregated.
Anybody else?
Therefore, it should be cancelled totally.
But Mr. Bhushal was there on the other side, not that time. So I would respectfully say, request him to be on that side again.
Anyone else supporting Mr. Rahim and Mr. Bhattacharya?
You can't be on that side and then here.
Anyone else supporting both of you?
I would
Only two of you then.
may I only send to state since
If Mr. Vikram or Mr. Firdaus wants to add a line, Milord, they are youngsters, Milord. I told them that this court would hear everybody, Milord.
I
just want to place one thing. The School Service Commission and the state must come up with a definite stand. And before the High Court, they have not come with a definite stand how as to the number of illegalities. Even then, courts of hearing, my lord, one after another affidavits came up, but the stand of the state as to the definite number of illegalities, neither the state nor the School Service Commission could submit before the court. And what I want to respectfully submit, your lordship, is that whether illegalities would exist in future or not, after the identified numbers. In that event also, my lord, the chairman of the School Service Commission is physically present. He also cannot say throughout the entire selection process whether further number would come out or not. He is personally present before this court. With this, my lord, I end my submissions. Thank you.
My lord, I am supporting Mr. Rahim and Mr. Bhattacharya, my lord, only on the 4 affidavits that have been filed before the division bench, my lord. The first affidavit, there was a full bench decision of the School Service Commission. After the first affidavit, the second affidavit came saying that the first affidavit is not exhaustive. They gave a list that these are the number of illegalities, where, my lord, certain illegalities were not given. Third affidavit, they say, my lord, it has been already placed that identified so far. And the fourth affidavit, my lord, which has also been placed before your lordship, states that in clarification of the third affidavit, we found that these are. So till date, the division bench gave them chance to file 4 affidavits. SSC is not clear what is the figure, exact figure of illegalities, because, my lord, kindly one thing, since there are 100 vacancies and 150 candidates have been appointed, my lord. So who are those extra 50%? SSC cannot identify. My lord, admittedly, 100 recommendations, 200 appointments, and they are saying that we did not issue. And this has come from Justice Bach Committee reports also. Those persons are not identified. And interestingly, my lord, if your lordship sees the written submission of SSC filed before your lordships, they have not said, they have not given the figure who have been appointed after more than vacancies and more than recommendations, only because these cannot be segregated and these cannot be identified. And other, my lord, I adopt the submissions of Mr. Bhattacharya. Wait.
In addition of submission made by my next senior friend, my lord, but I just give the impression which my learned friend time and again says that we gave the figure before this court. My lord, kindly take the final compilation volume 6, which is in written submission given by the School Service Commission, page 16 and page 17. The figure which is given by the School Service Commission before this, sorry.
Yes.
The figure which is given by the School Service Commission in this tabular chart, and if we add these 3, that is rank jump, out of panel and OMR sheet issue, the number came out 5,485. And the my lord will remember the last occasion on behalf of the board, one tabular chart handed over, which is this, my lord. And if we add this number, so that come out 5,189. Even the document which is placed before this court, there is also mismatch between these 2 Article 12 authority. Apart from that, my lord, the expiry of the panel, which is evident from this tabular chart, that is out of panel and expiry of the panel. Kindly turn, my lord, volume 5B, page number 2966. A tabular chart which is given where, my lord, it is evident the publication of final vacancy dated 11th September 2017. And according to the Rule 15 of 2016 Rule 15 is page number 959. May I read the Rule 15?
Yes.
Rule 15 says validity of panel and waiting list. May I read?
Yes.
Each panel and waiting list shall remain valid for 1 year from the date of publication of the panel and waiting list or the date of advertisement for the next selection test, whichever is earlier, provided that the names of the candidates shall not be recommended against any post other than the post applied for or against any vacancy which has not been notified in terms of clause B of sub rule 3 of rule 8. So it is evident from this rule
validity of panel is 1 year. Kindly see turn page number 2966. That second 2966 of volume 5, 5B, 2966. Very interesting, my lord. Date of publication of result is 11 September 2017. So panel validity lost on 11 September 2018. Kindly see my lord, date of counseling. First date of counseling is 16 July 2018 to 22nd July 2018. Second round of counseling 29th August 2018 within the validity period of the panel. The next counseling, third counseling, after expiry of the panel. Fourth counseling, after expiry of the panel. Fifth counseling, after expiry of the panel. Sixth counseling, after expiry of the panel. So, every counseling hold after second round of counseling, it is regarding 11-12. My lord, kindly see the 9-10, page number 309, 3009, a tabular chart which is evident that date of publication of final panel 12 March 2018. So, the panel validity expired on 12 March 2019. Kindly see the date of first counseling, 12 March 2018. Then second counseling, 5th February 2019. Then third counseling, after expiry of the panel. Fourth counseling, after expiry of the panel. That's to up to 8th counseling. So, in their affidavit, they say only 8th counseling is after expiry of the panel. But rule says, from third counseling onwards, every counseling after expiry of the panel. That's my humble submission, my lord. So, my lord, whole selection process, the submission, which is done before this court as well as the written submission.
Counseling, because personality is personality.
My lord, may I, my lord, place the rule. Rule is that, my lord. First, if this selection process is 100 marks selection process. Out of the 100 marks, 55 marks for written examination, 35 marks for academic excellence and professional qualification, and 10 marks for the interview. After 55 marks evaluation, they ought to publish a list that called interview list. They publish the interview list in accordance with law. Rules is that very specific. My learned senior friend placed the rule. Rule is that they ought to publish the marks with breakage of marks. In the year 2018, they not publish the marks. They gave the one-to-one communication, which my learned senior friend says.
No problem, they publish a list without the marks.
Yes, my lord. Without a mark, and that too, my lord, that too not in interview list, because in the rules there are 3 type of list. May I place this rule if my lord's one? If my lord not one, I place it because the whole rule is, my lord.
12-6. 12-6.
12-6. May I place the rule, my lord?
Rule
2 is the definition section. There are 4 type of list. 2F says about interview list. 2F. May I read the page number 955. 2F says about merit list. Interview list. Interview list means interview list means a list of candidates to be called for personality test, category wise on the basis of merit, marks of written examination, academic and professional qualification, in the ratio of 1:1.4 of final vacancies. Suppose there is 100 vacancies, so they ought to publish 140 candidates' marks with all details as an interview list, but they not published it. It is pre-interview, and after interview there is a list that called merit list. That merit list definition is also in the rule. Kindly take the definition of merit list 2G. 2G says merit list means a list of candidates prepared category-wise on the basis of marks obtained by a candidate in written test, in academic and professional qualification, and in the personality test. But in the year 2018, they not published this merit list in accordance with rules. We came before this court in the year 2021, when we came to know about that candidate, some candidate who are the less meritorious candidate, whose number is whose merit position is less, because number is at that point of time number was not published. Number published in the year 2022 when the court gave that direction. In the initial year, in the year 2018, they not publish the even interview list. They only give one-to-one communication to a particular candidate.
Interview list is probably published. We just get the clarification from them. They're saying interview list was published. It was not 1:1. And then they published the final list, pursuant to which probably when appointment letters were issued, some people got hint of it, and they then filed that why is marks list not been published. So then the mark list got published. When the mark list got published, then the whole thing blew up.
With the best of respect, that is not the position. Position is that there are 4 types of list. One is interview list, another one is merit list, another one is panel, and another one is waiting list. Suppose pre-interview, they ought to publish a list that's called interview list.
We have understood that. We have understood that.
Post-interview, merit list. And from that merit list, 2 types of list will be there. One is panel, another one is waiting list. So they ought to publish 4 lists. But instead of that, they publish 3 lists. I'm extremely grateful for patience hearing, my lord.
Well, next Monday, my lord, there's a holiday, my lord, in Vasant Panchami. So we will all be having.
No, we will not be probably.
Can it be on 4th, my lord? Can it be on 4th, my lord?
It's not a holiday. It's not a holiday.
It's in Calcutta.
It's in Calcutta. All of us, because I have to take certain submissions. But we have puja at our chamber because Saraswati Ma, like, can it be on 4th, my lord? Only, well, can it be on 4th? 1 day's accommodation, my lord, we are seeking, my lord.
Then it will go to next week. Beyond that. No, Friday we are not seeing it. 10th. And 10th we are going to conclude whatever way we want.
Keep it on Monday. Councils who are here, we can finish your lordships.
Friday may not be possible.
Your lordships Monday, your lordships is.
Lordship, can it be on 4th? That's
problem. Just say we can't help it. We'll keep it on 10th.
Councils will argue.
Okay. Yes, please.
My lord, so last time I had mentioned the transposition application, and my learned friend had said he wants to examine it. It's fairly uncontroversial. I was an appellant in the High Court. This man just didn't have the resources to file a petition. He's a legal aid candidate. Can he just be transposed? Well, as I hand up the IA number.
Very bad practice way from him.
He was.
2 p.m.